Can we have a big round of applause for the esteemed panelists joining here with us today? A very good morning to our esteemed dignitaries, respected faculty members, and participants. I welcome you all to the second day of the second edition of the NLIU-SBA Law Conclave. After a day of enriching deliberations yesterday, we gather here once again with renewed energy and purpose. It is now my honor to begin the third panel discussion of this conclave. Allow me to first introduce the distinguished panel for this session. We are privileged to have with us Mr. C.V. Raghu, Mr. Shujat bin Ali, Ms. Sonal Basu, Mr. Ruben Chako, and Mr. Pranjal Bhattacharya. If I may now take the opportunity to introduce each of them personally. We are delighted to welcome today Mr. C.V. Raghu as our distinguished speaker, an award-winning general counsel with over 4 decades of experience. He has been repeatedly nominated among the top 100 general counsels by BW Legal World. His career is distinguished by his role in major M&A transactions and his work with industry stakeholders and regulators. Mr. Raghu is also a certified Six Sigma Black Belt and has completed a program on negotiation at Harvard Law School, reflecting his commitment to continuous professional development and cross-disciplinary service. Most recently, in 2025, he led a webinar on the future of legal careers. His dedication to mentoring the next generation of lawyers, including the role of mentoring at Otis Law offices, further underscores his impact on the legal community and today on us as students. We're truly honored to have him here with us today. We are delighted to welcome Mr. Shujat bin Ali as our distinguished speaker. A fellow member of the ICSI, he holds a master's degree in law with a specialization in alternate dispute resolution and international commercial arbitration. He has completed executive education programs in strategy, general management, and leadership from Harvard, the Indian School of Business, and the NLSIU. He has been recognized as one of India's top 100 general counsels by the Legal 500, the Business World, and Forbes India. He's also been honored as a distinguished legal mind of India and one of the finest general counsels of India for the years 2023, 24, and 25. He's also a certified professional facilitator from Deloitte University. And Mr. bin Ali also holds a certified mediator credential from the Singapore International Mediation Center and a DDI facilitator certification. With that, I would now like to introduce to you our third panelist for the day. We are delighted to welcome Ms. Sonal Basu as our distinguished speaker. She holds an LLM in corporate and commercial law from the London School of Economics and Political Science, where she was awarded the Cambridge Commonwealth Scholarship. She has authored scholarly works including Data Science to Drive Good Governance and Bitcoin, Bubble or Reality, published in Computer Law Review International in 2014. Ms. Basu has been recognized as one of India's top 100 general counsels by BW Legal World for 3 consecutive years, 2020, 2021, and 2022. She has also completed an executive program on women on boards, social impact in the development sector at the Indian School of Development Management. We would also like to welcome the chief guest for the day. Can we please have a big round of applause for the chief guest of the day? Since we have our chief guest joining here today, if I could now reintroduce our panelist number 1, Mr. C.V. Raghu. We are delighted to welcome you here with us today, sir. For the audience, he's an award-winning general counsel with over 4 decades of experience. He has been repeatedly nominated from several distinguished organizations, namely BW Legal World. He has a role in major transactions all over India. He's a certified Six Sigma Black Belt and has completed a program on negotiation at Harvard Law School. Most recently, in 2025, he led a webinar on the future of legal careers. He has a dedication to mentor the next generation of lawyers, including his role at mentoring at the Otis Law offices. Today, he will be mentoring us as law students here today. This underscores his impact on the legal community. We are truly honored to have you here with us today, sir. Introducing panelist number 3, we're delighted to welcome Ms. Sonal Basu. Talking about her publications, she has authored several works, including Data Science to Drive Good Governance, Women on Boards, Social Impact in the Development Sector, which was published at the Indian School of Development Management. Her most recent professional achievement was her appointment as a Senior Vice President and General Counsel at Ascendian in September 2025, a role in which she continues to provide strategic legal leadership in the information technology sector. We are truly honored to have you here with us today, ma'am. We are delighted to welcome Mr. Ruben Chako, partner and regional co-head of the capital markets practice at Cyril Amarchand Mangaldas. With a distinguished career spanning over 2 decades, he stands at the forefront of India's capital markets. He has advised on some of the most intricate and high-value transactions in the country and in the field, with expertise that spans a wide spectrum of capital-raising transactions and security issuances across both domestic and international market frameworks. His work reflects a strong commitment of capital-raising transactions and a very nuanced understanding of the field per se. Over the years, he has advised companies across a diverse range of sectors, resulting in several notable transactions that underscore his expertise, professional credibility, and the trust that has been placed in him by the industry themselves. He's also an alumnus of NLIU Bhopal, and his journey from these very corridors to a leadership role within one of the country's foremost capital markets practice makes his presence especially meaningful here today at NLIU. His insights are expected to bridge academic discourse with real-world market practice in a thoughtful and very practical manner. It is a privilege to host him as a part of our panel. We are delighted to welcome Mr. Pranjal Bhattacharya as our distinguished speaker. The partner of the Energy, Infrastructure and Sustainability Practice at AZBN Partners and a member of the Bar Council of India, he has co-authored the India chapter of the Chambers and Partners Practice Guide for Energy and Infrastructure M&A 2024, as well as the Associated Trends and Developments chapter. He has also been recognized as a recommended lawyer for projects and energy by the Legal 500 Asia Pacific. Mr. Bhattacharya has advised on a wide range of high-value transactions in the field, in the country, and outside the country. He was awarded the Gandhi Fellow from 2013 to 2015, which is a program run by the Kaivalya Education Foundation in association with Piramal Healthcare that selects 150 graduates annually for field-based work. We are truly honored to have you here with us today, sir. With that, if we could now move to the formal welcome of all the panelists joining us today. As a mark of our deepest reverence, we now extend a warm welcome to the distinguished panelists gracing this dais. I would like to request our Controller of Examination, Dr. Manish Bahuguna, sir, to present a bouquet, a memento, and a shawl to Mr. C.V. Raghu on the stage. He's a legal strategist whose depth of experience has commanded quiet admiration. If you all could please join your hands together to welcome Mr. C.V. Raghu, sir. Please stay on stage. I would now like to request Mr. Manish Bahuguna, sir, to present a bouquet, a memento, and a shawl to Mr. Shujat bin Ali. He's a sharp legal mind known for his incisive analysis and unwavering professionalism. I request the Secretary of the Student Bar Association, Mr. Anadi Kesri, to come up on stage and present a bouquet, a memento, and a shawl to Ms. Sonal Basu, a distinguished practitioner whose contributions to the field reflect both grace and rigor. Thank you so much for joining here with us today, ma'am. I would now like to Thank you. I would now like to request the Vice President of the Student Bar Association, Mr. Yash Patidar, to come up on stage and present a bouquet, a memento, and a shawl to Mr. Ruben Chaco, a voice of clarity and conviction in complex legal discourse. Thank you for being here with us today, sir. I request the President of the Student Bar Association, Mr. Priyanshu Gupta, to present a bouquet, a memento, and a shawl to Mr. Pranjal Bhattacharya. He's a valued advocate whose insights enrich every forum he joins. Thank you for being here with us today, sir. The session we now embark upon is titled Beyond Degrees, Shaping Industry-Ready Lawyers Through Academic Evolution. A law degree, admittedly, provides the essential foundation upon which a legal career is built. The transition from legal education to professional practice often involves a period of adaptation, as graduates engage with the practical dimensions of courtcraft, negotiation, drafting, and client interaction. This session seeks to examine how legal education can continue to evolve in response to the demands of modern practice. The central question before us is this: what academic reforms and pedagogical innovations can better equip law graduates to navigate the complexities of the legal profession with confidence and, most importantly, competence? Let us explore the pathways that can strengthen the bridge between the classroom and the courtroom, between legal scholarship and professional application. Today's panel shall be chaired by Mr. C.V. Raghu, Managing Partner at CVR Law Partners LLP, President and Founder of General Counsels Association of India, and it shall be moderated by Mr. Pranjal Bhattacharya, Partner of the Energy Infrastructure and Sustainability Practice at AZBN Partners. I now invite our esteemed panelists to commence their deliberations. The floor is open for your discussion.
Thank you so much for the very kind introduction. It's an absolute honor and a privilege to be here today in NLIU Bhopal amongst all the students, the professors, and my esteemed panelists. As we open the session, it's a very interesting topic. There are so many students, law students, who are graduating every year, and the number is in lakhs. It is also undeniable that the quality of legal education has seen a remarkable journey in the last 2 decades. The quality of student intake has also become significantly better, so to say. Yet, this question still remains. are students industry ready? So as I open the floor to my co-panelists, maybe it's important for us to deliberate a little on what does being industry ready actually mean, and what is the expectation of the industry. We have a very diverse panel here, both from in-house counsels and law firms. So just if we could take a couple of minutes to provide that perspective, that what is the expectation of being industry ready? We can start with you, Sujat.
I think, firstly, the title, it's industry ready, right? I mean, I was just rethinking, it has to be possibly future ready lawyers, because that covers the gamut a little larger. It's not only industry ready, because as a lawyer, the options could be several. It could be, in-house as well. It could be the court, practice, or it could be a law firm, or it could be judiciary, it could be bureaucracy, multiple aspects. So I think the right framing in my mind is, future ready. I mean, how are we, ready to, cater the needs of the country and the society? That's one thought I was, having. And I've been interacting with a lot of, law students, as well law faculty, as well, and, across the, the industry. I mean, so what are the skill sets, or, what is the real expectation? Because we keep discussing about this day in, day out, that, I mean, there is a gap, what, the world is expecting, or the industry is expecting, versus the current, the quality, of the legal education and all. And when I interact with the students as well, I mean, what they say is that, I mean, what they are, exposed to is definitely great conceptual, clarity, knowledge of all of the doctrines and all. But how it is really applied, in the real world, I think that's the gap, what they see. I mean, when we look over all these aspects, I think, in terms of the syllabus as well, I mean, I think there is a greater need to see. I mean, I think some of the students who have interacted were mentioning that, I mean, in terms of the teaching methods, what was there, 10, 15 years back, even in terms of an assessment, I think the same is continuing today as well. Whereas, when the industry looks, in terms of, getting right candidates and all, they would definitely want someone who can be a go-getter, or, who they can immediately, start working on. Because, if it takes 2 to 3 years time to, build the competency and all of those aspects, it may become challenging. So, I mean, a lot of firms, or, the industries, they want to look someone who can actually, start working. And that's the aspiration, at least the companies would, or the firms would have. Okay, I mean, it takes time, for them to really, get in before the courts, or before the billable hours, or even to put any transaction, take 2 to 3 years of time. So, how do we, bridge that gap? So, in terms of the skill set, I think, the problem-solving skills, the critical thinking, the analytical, approach, the ethical angle, the interdisciplinary things, of course, the business awareness. I think there are a lot of these areas which, the industry definitely, they expects, alongside the, the soft skills as well. I mean, while law is there, the doctrines are there, the case studies, case laws are there, but how do they, apply, and, the interdisciplinary, approach, and, usage of some of those soft skills, so that they can actually, work on the particular project and all. I mean, they may be reading on the M&A acquisitions and all that stuff, but how quickly they can actually start working, on an M&A project and all. So from that standpoint, I think, of course, I'll keep, in terms of opening remarks, we need to think through, in terms of the syllabus, what changes are definitely required, whether it is attuned to the emerging terms. We are talking about ESG, sustainability, artificial intelligence, and energy related. So a lot of new changes which is happening, in the industry. So whether all those emerging, issues are there part of the syllabus, that is one. Two, in terms of the teaching methods or the pedagogy, I mean, how the teaching methods can change. I mean, gone are those days where students have a larger attention span. So how we can make the, the teaching more interesting, so that they really enjoy it like a real life story. So that is a significant change which is needed. And also in terms of, getting close to the realities. I mean, I don't think so only the, the internships and all will work anymore. I mean, a lot of law students, I mean, they just focus on internship. It will be more of a resume building exercise, but not the depth of it. So I think the rethink is needed, in terms of how they can acquire those practical knowledge. And last but not the least, in terms of the assessment also. I mean, is it still sufficient to just have a theoretical, approach, or enhance, the assessment in terms of case studies, in terms of problem solving, approach? I think that's a lot of debate which we need to do. But as a person from industry, I think a combination of all these aspects is what definitely people are looking. And now with the advent of AI and all that stuff, naturally the expectations have increased. So now industry expects also a lawyer who is also good tech savvy lawyer and all. So the expectations are no doubt increasing of the industry or for the firms and all. So, and when they look from outside, I think all of these aspects are being analyzed, and a view is being formed as to how do you hire people, or how do you make them industry ready or future ready. I think these are some of the initial remarks, and I think I look forward to add more on those specific thoughts, Ranjan.
So, Raghu sir, your views.
First and foremost, thank you NLU Bhopal for inviting us. It's actually always a privilege and a humbling experience to sit in front of such audience gathering and young minds. As regards the question of industry rating, this question will never get answered in your lifetime, my lifetime, or the next generation's lifetime, because the industry is always evolving. But as somebody had once told me, I would rather hire a less competent guy with a better attitude and better orientation to life than a brilliant guy who's a very stiff-nosed and difficult guy to handle. So I would urge, in today's world, as each one of you is racing, you guys are literally racing. In our times, we never used to race. There was a lot of, वो हिंदी में कहते हैं ना, ठहराव था लाइफ में, आराम से सब चलेगा, सब होएगा. लेकिन today there's this peer group pressure. You want to run, that is the race you want to earn because you're spending a lot of money in your education, and it's always about a race. How better am I than my peers? Whereas in our time, we were happy if our peers are doing well because we knew that we'll also do well. It may be today it might be Sonal's time, tomorrow it'll be my time, something like that. But today, and on a lighter note, I actually blame my two friends who are sitting on the two corners from law firms. They are the people who have actually created, and A0 will get so much salary, and A1 will get so much salary. That creates a peer group pressure. People who are not paying into the law firms believe that I have lost out. Whereas in reality, nobody loses out. Law is such a fabulous profession that it's a matter of time before बोलते ना आपका नंबर भी आएगा, और आपका नंबर जब आएगा nobody can stop you. So I always believe you must have the right orientation, right attitude. You always have people who will find a problem in every solution, and there are people who find a solution to every problem. So be the second, be the latter, and don't be the first one. And there is no second route to hard work. Law school can try the level best, but they cannot make them industry ready because there's a syllabus to which they operate. Industry ready will happen only when you come into the industry, or life ready will happen when you start working on the road. और किसी ने बोला था ना, बड़ा अच्छी कहावत है, father doesn't leave the hand of the child because if the child starts running, the child will fall. But at the same time, if the father doesn't leave the hand, how will the child learn to run? So the question is that you have to start working on the road, you have to start working with the right attitude, and then life will take its own journey. Life is very beautiful. Please don't, I can say this with fair amount of certainty that every student who's sitting here will do well in life if you have the right attitude. If you want to do the wrong things, then God only can save you. But if you're doing the right things, it's a matter of time. And for industry readiness, your choices will vary, And for you, different people, different industry. Somebody wants to be a law journalist, then your industry is how do you write journalism, how do you write articles. You want to be a judge, there's a different duration. You want to be an in-house counsel, there's a different orientation. You want to be a practicing counsel, it's a different orientation. So that's your industry. So it's not like a capsule that you have the capsule and you are industry ready. No. You must have the right attitude, right mindset, right ability, and right willingness to work hard. Law is a profession where if you don't want to work hard, leave the profession, do something else. It is a profession where you have to work hard. AI, no AI.com, all that. At the end of the day, you have to know what you're talking. You have to know what the law is. And for that, the only way is that you have to read, and read. Because knowledge can only give you confidence, and confidence will give you leadership. And when you become a leader, then you are on the top. And there are plenty of examples I can talk to you during break time, that there were lawyers who were third-class lawyers who made it to the top. In those days, there used to be first class, second class, third class. These days, it is CGPA, right? They give you some numbers, right? But because the Bar Council, to become an advocate, you just have to pass law. It doesn't say if you get 90%, you are a senior counsel. If you get 70%, Bar Council says you become an advocate. Thereafter, how good a lawyer you are is based on how disciplined you are, how motivated you are, what's your attitude to life. You want to solve a problem, or you are rigid, you are flexible. Because many times I've seen senior counsel stand in front of the judges, and the judge throws a counter question. So you have to be flexible, you have to be on the feet, you have to be worldly wise to be able to respond. And when you respond, then you get your output. So my opening thoughts would be, Pranjal, is that I would rather go for a person who's got a better attitude, ability to work hard, hunger to learn more, rather than a person who's very stiff-nosed, feels very entitled in life. In law, there is no entitlement. You have to earn your entitlement. There are no stripes that you get, whether you pass from NLU, Bhopal, or you pass from some government laws college in some remote city in India. At the end of the day, you are as good or as bad as your last brief, as they say. Right? I'll pause there. Yep.
Can't agree any better.
We'll move on to you, Somi.
So first of all, thank you so much for inviting me, all of us here. It's an honor, and it's always nice to go back to the world of academia. I take lectures at IIM Bangalore, and I love teaching, so always nice to be part of this community. This young lady, I didn't get your name, she spoke about, what's your name? Yeah, sure. She spoke about confidence and competence, right? You all are competent here. You're at the best law school. So I don't think there's any dearth of competency as far as you guys are concerned. Confidence will get built if you prepare yourself the right way, right? And my esteemed panelists did speak about it, but I think what's important to be industry ready is what kind of resilience that you've built over the last 5 years, in your law course. Do you have the ability to listen? Because when you start practicing, you need to listen to your client, you need to listen to your stakeholders. Do you really listen? And as a lawyer, to get your facts right, you need to patiently listen to what's been told to you, right? For you to provide the right counsel, right? So ability to listen, building that right kind of resilience, curiosity, that hunger to learn. I mean, all of us are, with 20 plus years of work ex, trust me, we are still learning because the industry is evolving, laws are changing. I've done my bachelor's in 2002 and we are in 2026, right? So there's a lot of development which has happened, especially in the industry that I am. So the curiosity to learn, that hunger to learn, that passion, that you drive, or your drive to to excel, that also comes with learning. The better learned, if you read more, you're more learned, and that reflects in the work that you do, right? So that's another thing. Fourth is, which is extremely important, and of course we have learned it the hard way, ability to accept that some of the professions are extremely demanding, right? You take a doctor's life. Doctors don't have a life, and I say the same about lawyers. Lawyers don't have a life. If there is a problem that I have to deal with, be it in-house or as a practicing counsel, if I go to a high court lawyer saying, hey, I want this order, injunctive order, he or she will have to listen to me even if it's a Saturday or a Sunday, because on Monday I would want that order, right? So that ability to reconcile that this profession is demanding and I'm going to enjoy the journey is something that is extremely important. And the last point which I want to tell you, all young, bright, budding lawyers, is just enjoy the ride. It will have its own ups and downs, but trust me, it's a beautiful ride. There's so much to learn. There's an impact that you would make. So just be confident. Don't compromise on your learning curve, and you will be industry ready. Thank you.
Thank you, Sonal. So I think you've heard a lot from the panelists already. I think once upon a time, maybe 20 years ago, I was sitting there. I was on that side of the table, and I think I should just try to be less of a, today I think I should hold myself as an alumnus of NLIU more than being a partner of a law firm. So I think I'll try and do a role reversal here. But I'll just tell you an interesting fact. My first internship was with Sonal. When I was in my second year, I interned under Sonal at Wipro. So I'm so glad to be sitting on this panel with you today, and that's aspirational, right? So I think the way to look at things in life is, all of you are sitting there today, and there will be a day where you will be sharing the dice with one of us or with such other senior professionals in the industry. So I think journey starts from, inspirations and what your aspirations are. So I think the ability to dream is, I think, very important. You need to know while you're sitting there, what would you like to be? I think Sir touched upon it already. Being in a law firm, my comeback line to him would be that, I don't think being in a law firm is a big deal. Like, I really don't think, after having been in Cyril Amarchand Mangaldas and erstwhile Amarchand Mangaldas for almost 2 decades, I really don't think getting a job is not that difficult, but to sustain that job, I think, is the task. And that requires, different kinds of skill sets, not just knowledge of law, and I think we'll touch upon it, I think, during the course of this conversation. You need to have various kinds of skill sets to be able to be relevant, to stay relevant, and Sonal mentioned that already. I still, if I'm not working, if I'm not working on a transaction that has come to me, I feel FOMO about it. Like, I can't, even as a senior partner in my practice, I still work with my junior lawyers on each and every transaction of mine. I need to know everything that's happening. I would like to be briefed, on what are the issues, because Sonal is a potential client of mine. Like, a GC is a client of mine, and the GC is not going to call the junior lawyer. She's going to call me and ask me, hey, what is happening on my matter? And I better know what is happening on a matter. And by chance, if I'm not prepared enough and I don't know what is happening, and I cut a sorry figure. So it doesn't matter how long you have been in the firm, what your designation is, what your title is, it just doesn't matter. What matters is, do you know what you're doing? And that requires work, that requires a lot of hard work. So these are the things that you need to instill in yourself, in you, right from the beginning. I think, like Sir mentioned, there is no shortcut to, putting in time, hard work, reading, etc., etc. Like, today is a day and age, and I feel a little concerned as well, because, of course, I am like, if I were to put it in cricketing words, I'm like maybe a test cricketer. Today, I think, how many of you have the patience to watch a test cricket match, right? How many of you can sit and watch a 50-50, a 50-over match? I think more of you will be interested to watch an IPL, because it's just 20 overs, it'll get done in 3 hours. Maybe the highlights of an IPL, am I not right? As in, because your attention span is only for about half an hour, or maybe an hour, or maximum 3 hours of an IPL is what you are willing to devote. But if you're a true passionate cricketer, you actually can pull off watching a test cricket match. Or at least a 50-over match, because you're passionate about the game, you want to know how the game is progressing, how the batsmen and the bowlers are doing, so on and so forth. So if you want to be if you are a passionate lawyer to be, you need to have the patience and perseverance to be at it on a day-to-day basis. Having said that, I don't think it's such a scary world out there either. I still believe there is work-life balance. I maintain a good work-life balance, by the way. I try to keep myself fit because I think fitness is important. I play sports still. I do find time for my family. I have a daughter who's 10, so I do spend time with her as well. Whatever I feel like doing, I make it a point that I do it. So it's a matter of personal choices that you make and to be able to stick to it. And the other thing I wanted to touch upon is, as students, we always have this, as a student, I did that too as well. I mean, you keep thinking that, the university has to do more for me, my faculty has to do more for me, I need to, I need to be guided more. The wants are always more. Like, the wants are constantly more. But please ask yourself the question, what are you doing for yourself? I do guest lectures in law schools in India and abroad as well. And whether you go to Oxford, Harvard, whether you go to a national law school in India, wherever you go, the problems are the same, trust me. It's the same set of problems in varying proportions that's there across the globe. So trust me, your problems are everyone's problems. So then leave that behind you and focus on yourself, focus on your skill sets, focus on what would you like to become, and take baby steps, and that's what you need to do. So when you say industry ready or future ready, as the case may be, the point is, where do you see yourself, and what would you like to be, and what are you doing about that? Even like a very small habit that I picked up when I just started working is to, make it a point that I read a business newspaper every day. And I've been doing that for the last 20 years. Like, I don't think a day has passed by without me having gone through what's happening around me. Because you know what? When I go for a meeting, more than the negotiation that I do or more than the meeting that I do, over coffee or lunch, when I have that small chit-chat with my client, the conversation could be about what's happening in the US, or how is the stock market doing in New York, or what's happening between the India-China treaty, and so on and so forth, or who won yesterday's match. And I like to have an answer for every question. And you know what? I feel FOMO otherwise. It's good to have an answer. It's good to have a comeback line. It's good to know. So which means to know you need to read, which means you need to have your mind open. It's not just about reading law books. It's definitely not just about mastering constitutional law and trying to think that you're the best, you're God's gift to mankind. You're not, trust me. So there is a lot more that each one of us can do. I still feel that I'm an A0. Like, I still feel that I'm a junior lawyer because that's the passion with which I look at each transaction that I do even today. Like, any new work that I get, I do it with the same amount of vigor and passion with which I did when I had just joined right out of law school. And that passion keeps me going. And I make it a point that 100% I learn something new on every matter that I'm doing. How do you think I've been able to sustain this job for more than 18 years in the same place? I mean, I should have gotten bored, logically. There are different ways in which you make your career. And, all of us sitting on this dais have made our careers in different ways. There are people who, whether it is, let's just talk about a law firm world. In the law firm world itself, you work in a firm for a couple of years, and then you move to a different firm for a couple of years, and so on and so forth. I mean, that's a perfect way to make your career as well. Like, you get better at what you're doing, you're in demand, somebody's willing to pay you more and give you better opportunity, and for various reasons, you move to a different organization. But you know what? Looks like I'm a test cricketer. I have always been too loyal to the place that I've belonged, perhaps. And that's just a personal attribute. I don't think nothing excited me to change my job. So I have had the same job for the same place over the last 18 plus years. And that was my choice. I'm not saying that's the best choice, but that was my choice. And on account of which I'm doing reasonably well and I'm happy with what's happening. in my career. All of you have, I'm sure, like Sonal mentioned, each one of you sitting here is bound to do well. I was sitting there at one point in time. There was not even this auditorium at that point in time, but still, I was, metaphorically, I think I was sitting as a student of this university maybe 20 years ago. And here I am today talking and sharing my experience along with such esteemed panelists with me. It's a fantastic moment, and I feel humbled, and it's great to be here, and I'm sure that each one of you will be in this position as well, but never forget the journey. And I still think, and I have a lot of respect for all the faculty members here and the teachers who taught me, because the ABC of law I learned in this city, in this campus, and I think 1/3 of my success, at least, I owe to this college, to this university, and it belongs here. And I don't think, and I'm not saying for flattery or, I'm not saying, and I mean what I say. I think a lot of support from my family, and of course, a lot of my success I owe to my clients and the work that I do and the firm that has backed me for so long as well. But the first 1/3 goes back to this university, and I genuinely mean it. And I think everything that I've learned started with the basics of law that I learned here, and I learned that pretty well. And those were the building blocks that got me to where I am today. So thank you so much for this opportunity. It's lovely to be here.
So just to pick up on Ruben's cricketing analogy, as we have seen with Indian cricket now, the younger players who are coming into the setups are much, much well prepared, and they are not intimidated or overawed by the bigger stage. If we are to draw a parallel with the legal industry today, one, where do you see is the biggest gap that exists between the industry expectations and what a fresher or a very young lawyer is able to bring, somebody who's just right out of college or has spent just 2-3 years into college? Are there the softer elements, softer skills that are involved, and what would those be in your early years that sort of take you the extra mile? And say from a hiring decision perspective, when you have to choose one candidate between 10, what is that one X factor that does change the perspective in terms of hiring, either in terms of law firms or in-house? Is there something that law colleges and universities that can do to bridge that gap, as we have seen with Indian cricket happening? Or are we expecting too much from law schools and too little from our freshers? Maybe we can
I think
start.
I can start from a very law firm sort of point of view, and also having been part of the recruitment team in the firm for the last several years. I've come to this campus as well multiple times, and and to other campuses too. It's true that there is so much of competition out there. I heard today morning there are 23 national law schools, other than, of course, other large law universities as well. I think a large number of students graduating every year. Of that large number, maybe a small percentage are aspirants of law firms, and that's where I belong. And within that small group, which is fairly large, I need to pick the right minds, the right talent. And I think the most important thing I look for is exactly what Sir told earlier, is the right attitude. And like Sonal mentioned, it's a combination of the points that you heard already. Like Sonal mentioned, about the fact that all of you guys know or mostly know your concepts pretty well. You've attended classes, you know your law, you know your subject, and that's the expectation. By the time you have reached your final year and you're appearing before an interview board of a firm, perhaps, or any other organization, so you know your subjects reasonably well. You've also done your internships, and you've spoken about it, and you've tried to do everything possible to highlight your CV as well, which is all there. So, but I think one thing that I look for is, do you have the right attitude as a person? Are you potentially going to be a culture fit in my organization? And do you have that long-term, if not too long-term, at least a medium to long-term vision about where would you like to be, and are you serious about this opportunity that I need to give you? Like, or is it a low-hanging fruit for you? Like, you know what, I mean, I just need to start somewhere. So, you know, I'm going to apply to 10 places and maybe 1 out of the 10 has to click. Is that the mindset, or is there a deeper reason? Industry readiness is all about having that deeper reason. Just one example, I think last week I was judging one of the competitions organized by NLIU, the symposium on capital markets. I was very happy to actually have been part of it. The reason I took time off to do that, I mean, I couldn't come, I did that online, but the reason I took time off and you know, decided to judge the finals of that event is because I don't think any other national law school yet had done an event like that, like a research paper, presentation, competition in securities law and capital markets, which is what I do. You know, that was quite interesting. While I went through the papers, the research papers, I was fascinated to see the depth of research that has gone in preparing it. Initially, my mindset was somebody would have copy-pasted from different sources, used AI, ChatGPT, whatnot to prepare it. It's no big deal, right? In 20 minutes, I can write a paper right now, like using AI. That is the mindset with which I started reading those papers. But as the panel started grilling the participants and we started asking questions, I was amazed by the kind of responses that I got from some of them, which means that there are few who are interested and passionate about that particular field, as specialized as capital markets. I had no idea what capital markets stood for when I was graduating. But that is definitely not the case today, which means, coming back to the example that you said, the young lawyers or the budding lawyers today, I think, are getting better prepared because they seem to be developing interest in certain areas already, at least towards their maybe 4th, 5th years, and they are picking those areas and doing a deep dive. And irrespective of the fact that they may not be coached formally in the university, there may not be a module or a program specifically for that, but nevertheless, they seem to be putting in effort. And that is what fascinated me, and I think that should continue.
I think we can move with you, Somi.
So I would give an in-house perspective. If I were to hire a young lawyer, I would not expect too much in terms of the technical expertise, because a field is like an ocean, you know. I could be an expert in data privacy, I could be an expert in taxation laws, I could be an expert on the disputes front, you know, or I may explore compliances as my field, right? So that's something that you build over a period of time, and when you're, 22, when you pass out, literally 18 or 22? 22, right? 22, you're not expected, 23. Yeah, you're not expected to know everything. But what I would definitely look for is, are you aspirational? Are you well connected? Do you know about the organization that you're joining? Do you know about the industry that you would want to work for? Have you read about the leaders? What do you know about, you know, what the company's aspirations are? Have you gone through the website? Do you know the real problems that the industry is dealing with? You know, those are the areas which I would assess you on, not how much you know, because that would be taught to you as a young lawyer. You'll hone your skills and you'll start delivering, right? So my focus would be on how passionate you are about the journey that, you know, you would be embarking on, and how connected you are with the industry or the job that you would want. So that is something that I would look at.
Raghu sir, your views on this?
Before I respond to this question about hiring, I just want to clear a little bit of haze on what Ruben said. Ruben mentioned that he's been there for 19 years with CAM, right? He said that 3 times since I met him last evening. You didn't notice, but he said that 3 times. And I was thinking that what has kept him there for 19 years? The reason why he's there for 19 years is not that the job has not changed. He has evolved the job from where he started to a very different job. So he doesn't have to find a job in a different company. He's there within CAM, but the job that he's to do in the first 2-3 years is very different from the job that he does today. And he has himself evolved that job to become larger and larger and larger. And that's what keeps him going. It's a known environment, that's why you're there. So I'm just trying to clear that haze, because people should not think that spending 19 years in a particular place, he doesn't get a job anywhere else, therefore he's stuck there. No, that's not true. The reason why he's there 19 years, that the firm respects him, and the firm respects him because he has evolved the job to a very different stage. Please, so tenure has its own advantages, and it has its own contribution to equity, right? That's one. The second thing, Pranjal mentioned about cricketing. I love cricket as well. So the difference between T20 and Test cricket, I'm equally impressed with, what's that fellow's name? Vaibhav Suryavanshi and Abhishek Sharma. But I'm a big fan of Sachin Tendulkar, who played Test cricket, who played one day, who played T20. And the reason why he did that, there was a consistency, there was a dedication, and there was a, you cannot take away the technique part of it. The technique is very important. So in law, you can't do shortcuts. I know a lot of, this jugaad doesn't work in law. You have to know the law. You have to know the law. You should have the clear argument to be able to argue, whether it's your, and it could be, if you're a practicing lawyer, it will be a judge. If you're an in-house lawyer, your chairman, your promoters will ask you. If you are an IP counsel, somebody else. If you are a journalist, your editor will ask you. But you must have your technique right. It's important to have. And I'm not sure that whether this country, with all good wishes to the Vaibhav Suryavanshis and Abhishek Sharmas, will produce another Tendulkar or another Virat Kohli in this country. That's because of the technique, and that's because the fitness, look at the amount of discipline.
We have Yashasvi Jaiswal for that.
Yeah, I'm not disputing. I'm not taking away anybody's credit, but I'm saying they are role models, because today, if you look at, after 1 year gap, Rohit Sharma and Virat Kohli come back, and both of them score about 70, 80 in a T20 format, which they have retired 2 years back, right? So it's about how much this discipline that they have. They go to the gym, and people say that Virat Kohli is fitter than even the guys who are 21 and 22. So that goes to demonstrate the dedication, passion that they have. Coming back to the most important question about hiring, I fully endorse everything that Sonal said, Ruben said, in the sense, it's about attitude, it's about tenacity, it's about hunger to learn more, it's about, and please don't have a chip on your shoulder, because, and I'll give you, today you at least have the explosion of information. When I went for my first interview in Unilever, and I was sitting in front, by the way, I am so impressed today, I was telling Anshuman that all of you wear those black suits and all that. We did not know, we had to borrow a shirt to go for an interview. We didn't even have formal shirts those days. So, and I sat in front, and I suddenly find my interviewer 3 or 4 different kinds of soaps. I knew Surf was from Hindustan Lever, but I never knew Rin also belonged to Hindustan Lever. I never knew Wheel also belonged to Hindustan Lever. So I was saying, what are all these competing brands doing on a table? That was my ignorance at that point in time. I did not know that all 3 brands belong to the same company. But in the marketplace, and my information was based on market. A Surf is competing with Rin, and a Rin is competing with Wheel. But that's what they have created in the market, right? But all 3 brands belong to them. So the question is that information should also be distilled, and you must take all the relevant information with a fair amount of your own logic in. And in the organization, one question that you'll hear as you step into whichever sphere of legal practice that you get in, there is favoritism, there is politics, there is people who are bad bosses. All this is trap. And I'm saying this with my hand on my heart. All this is trap. I've had different bosses. I've had different organizations, different cultures. It's your ability to adapt. Adapt without compromising anything. Please trust me, when you say adopt, you might think that ye chaaplusi karta to sab jara. Nahi. If people who have interacted with me will tell you, I am the most straightforward, difficult guy to handle. I'll tell you. But you have to be very logical. You have to go by a value system. And each one of you has got this value system from your mother, your father. And there's no new value system. Please get it right. Parents will always teach you to be truthful. They'll always teach you to be respectful. They'll always say, learn it, don't do the wrong things, don't have shortcuts. How often have you heard that please don't do shortcuts, because the right path is the longer path and the more difficult path, and the wrong path is the shorter path? I'm sure in some conversation somebody would have told you, right? The question is that it only goes on to say you have to work hard. There's no shortcut. And coming back to what Ruben was saying, pursue your passion as well. Because in your bad days, your passion actually keeps you going. Not your knowledge, not your degrees. If you are, like today, this morning, Sonal was saying she started playing golf. And I was so delighted in the sense that, and I believe everybody in her family, she's got 2 sons and husband, all 4 of them play golf. What a fabulous thing for a family outing. Every Saturday morning you go at 6 o'clock, come back at 10, 4 hours of quality time with your family. And she doesn't need a work-life balance. That's the balance. Thereafter, I'm sure the kids must be missing her all the while. Yeah, the husband must be missing her all the while. But the question is that you are still pursuing your passion. You know what you stand for. Stand for your value system. Create a brand of your own. Please create this brand of your own, which is very important. If any one of you wants to read a book, I can refer. There's a book by Tom Peters, The Brand You. Please read that. It's a very small book, but it talks about that everybody is a brand of their own. Why do you know when somebody says, yeah, I met Pranjal. Oh, Pranjal. So you suddenly have an image about it. That's the brand, right? So you can create a positive brand, you can create a negative brand, but you must create your own brand. If you do that, and success is not linear, please, or vertical. Most often we all believe success has to be very vertical. It is not vertical and it's not a straight line. Trust you me, I've worked with multinationals, I've worked with Indian promoters, I've worked with Indian multinationals, and I've also had the privilege of being a global head for a company that was born and brought up in India but operates in 42 markets. And imagine the Europeans and the Americans having an Indian as their head. Not digestible, but you have to manage. That is where your skills come into play. And it's not because you have the gift of the gab. That's because you have to demonstrate you are more knowledgeable than them. Because people only respect knowledge. People don't respect because you are the chairman's appointee. No, there are 1,001 ways of bypassing that. So be very clear. And when it comes to hiring, I would rather go with a person who's got humility, fire in the belly, and doesn't have competence. I'm going an extreme step. Competence is something that can be trainable. I can always make him sit. If he or she has the will to learn, I can tell, go there, and I can put you onto 10 coaches also. But if you don't have the attitude, only God can save you. Only God can save you. And I've told people, if people have the wrong attitude, they will always keep struggling. Always. Because they feel the whole world is actually conniving against them. And they become high maintenance for you. So don't hire them. Don't hire them. Because high maintenance, you don't have the time. We all have a full day job. All are accountable. I can't keep spending 5 hours with a guy. ये हो गया, वो हो गया, ऐसे हो गया, वैसे हो गया. मतलब, you know, and these are all fit. वो बोलते ना हिंदी में, वहम का कोई इलाज नहीं है. Do you agree or not? वहम का कोई इलाज नहीं है, और जिसका वहम है ऐसे बंदों को हायर ही मत करना. I'll pause there.
Yeah, I mean, a lot of things have already been said, but I have few specific things from you talked about brand, and value proposition. So if a law student would come and ask me, how do I, start building my brand and my value proposition, or how my CV can look meatier so that I can attract the best opportunities. I mean, this is a common question a lot of students come and ask me, and I have just noted down a few points which I want to share with all the benefit of the students. Firstly, I think apart from the academics and all, which is all going on, the extracurricular activities are definitely important. I mean, a lot of people say moot courts hota hai, but apart from moot courts, what else you can do? Right now, these days, the mediation competitions are there, arbitration-related competitions are being happening, negotiation-related, discussions, client counseling-related stuff, M&A labs. There are a lot of ways, which are there. I mean, like tech hackathons, you have legal hackathons, which are happening. And a lot of conferences, are being organized across India, virtual and physical. And of course, a lot of students do keep saying that, the colleges doesn't permit and all. I mean, instead of blaming the college and all, I think as an individual, what all you can do, right? A lot of law firms are actually offering webinars on the emerging topics. You just need to keep track on whatever is, happening and attend those conferences, those webinars. And now, I mean, sitting here with the virtual world and all, with YouTube and all, you can see what's happening in Harvard and all of those lectures are available, for free. So again, it's just that the students have to, start thinking how do I can add all these elements into, my profile. And not only that, network is net worth these days, right? From that standpoint, how are we building the network, of the professionals over a period of a time? And each person who you meet, what's the best you can get it? And have a set of mentors. I mean, like we have the alumni and all. I mean, start thinking, in terms of having a GC or a practicing advocate. Start having those people as a mentors early on, so that you can get practical, insights. And apart from the standard, internships, I mean, try to, possibly go and do some legal aid as well. I mean, you have a lot of, opportunities around that. In terms of following some CSR projects and working with some social related aspects of it. On emerging topics, some of the certifications can be done. I mean, these are all various, avenues. And also, I was just speaking to another student the other day, how frequent, I mean, today nothing stops you to go and actually attend some of the courts, field trips, like, attending a consumer forum or, attending a district court or a civil court or a criminal court. Or for that matter, go and see how things happen at a police station, right? Or for that matter, if you have an opportunity to go and visit some of the factories, visit some of the industries, all of these aspects, right? I mean, if you can start thinking, I'm not suggesting to do all of these, but depending on what they can do, if they start building these elements in their profile, and of course, all of these aspects will definitely help them to understand a little bit more. I mean, from a law standpoint, today it's the intersection of law, business, technology, geopolitical, what is happening in the world is very important. So from that standpoint, student has to build their own, the curriculum alongside, the academic curriculum. Of course, they need to spend some time and all, and today's world is all about distraction and all this stuff. So I'm not saying that, you should not have fun. I mean, in fact, I also, echo with Ruben, we talked about the life balance and all. I mean, I also disagree when people say that, okay, I mean, you have to forget the life and all. No, I think the whole career and education is part of the life, not the life itself. Of course, it's all about how do you balance these aspects. Now we are talking more about, the digital fitness, the spiritual fitness, the mental fitness. All of these aspects are equally important. It's not only the career part. So I think we need to make a balance out of it. So again, when we, talking about all of these aspects, I think we can pick and choose over a period of 5 years of your course. I think you can start thinking, these areas. And over a period of a time, when you like certain subject or like particular industry, I think you can start spending time around those aspects. Then I think you can, create a brand, out of you over a period of a time. That's something which I wanted to share. I think from a law college's standpoint as well, I mean, few thoughts which I have. I mean, if you see some of these IITs, IIMs and all, what they're trying to do, I mean, they're enhancing the industry-academic connect significantly. You will see in some of these management and tech colleges, we see the faculties are also doing some consulting assignments for the industries as well. So that way, apart from the revenue side of it, I think the affinity to the industries is increasing. I mean, so they're also working on some of the entrepreneurship projects, some of the research projects, and all of these aspects. So I think that is something which law colleges can start thinking in terms of how to collaborate more with industry and do some of the, leadership related stuff or consulting assignments, or where, best of the research abilities can be brought out is something can be thought through. And the faculties as well. I mean, we all need to learn, relearn, and unlearn, right? There's no doubt about that. So even from a faculty standpoint, I think it is equally important to see what are the things to be unlearned and relearned, or completely learn new things as well. That aspect also have to be strongly, put a focus around that. The executive education programs, I mean, like in IITs, they're actually doing a lot of executive education programs. Similarly, I think when law schools start doing that, I think a beautiful combination of what's happening in the real world and from the research, I think the blend would be really, good. So I think some of these aspects are definitely, the helpful. And overall, in terms of the leadership, soft skills, management skills, and those aspects are not there in the syllabus. So how, all of these elements can be embedded is something definitely can be thought through. And I think in terms of the teaching methods, as I was mentioning earlier, I think it definitely needs to go through a lot of change. I think people, the students who attend the classes, they have to really start doing it. I mean, when you're talking about a labor code, I think discussing the real issues, what's happening, I think that may make more sense, where challenges has to be given, a lot of debates and discussions needs to happen, a lot of project works has to be given. So that way, I think things will be much better from a student standpoint, because a lot of skills can be learned. So from that standpoint, I think a lot of special guests or industry people and practicing advocates or law firms spending time in the the college campuses will bridge that gap, is also what I feel. So I think these are some of the practical inputs which I had, which can be thought through by the law students and also by the law colleges.
I just wanted to add one thing. So I think a couple of things that he said, I think they're very relevant, and I think as NLIU, as you folks are already doing it. And that's something that I have seen over the last so many years. I mean, perhaps when I was in college way back in 2005, I think we didn't have, we perhaps did mode codes. I don't think we did, more than that. But today, there are so many different kinds of competitions that you organize and that you participate in as well, which is just fantastic. Like whether it's mediation, arbitration, writing research papers, and the traditional mode code competitions as well, which is great. Even I think one of us touched upon internships as well. I think it is relevant. I mean, I don't think internships are not relevant. It's about how. I mean, my only small advice to all of you would be that when you do an internship, it should not just be to write that on your CV. I mean, yeah, I know you will write that on your CV, and it's important to write it, but do it because you want to do it. And like Sonal mentioned, even for an internship, there should be a reason why you went to a particular corporate house or fund house or law firm or a lawyer's chamber. There should be a reason why you prefer to do internship with that particular person, individual, jurist, organization, and not just because it was just like something that I had to do during my summer break or winter break. There should be a reason why you did it, and while you do it for 4 weeks or 6 weeks or 8 weeks or whatever number of months, you should just give it your 100% and try to learn what you're not learning in law school, try to learn there. And that's the reason why you're spending that time, not just a pastime, right? So I think there should be more than, these are all food for thought. I mean, I know it's very easy to say these things and, and go from here. But, as students, I am sure you won't be able to think as deep as we are thinking, because we are experienced and we have gone through that life journey. You're still experiencing that journey. So you will make those little mistakes that I also made many years ago. But now that, the world is different. The world is not what it was 20 years ago. So the world is a lot different, and you can be sharper about it. You can be smarter about it. One thing that I didn't say earlier was, when I hire, I'm looking not for a hard-working lawyer, I'm looking for a smart lawyer, right? I want to know who is smarter amongst the 3 people I'm interviewing. Like, who has the right who has the fire in him or her, who has the passion, who has the interest, and that's exactly the topic today, right? That readiness is nothing but the passion. The industry, all these terminologies are cool to listen to, but ultimately it boils down to, do you have that drive, the interest and the fire in you to get to where we are sitting today? That's a very simple proposition, and to which you need to work for. And you need to think about, all of you are, none of you are kids here, right? All of you are grown up, you're all like, you're all adults and you're just getting into the real world very soon. I'm sure you know what is required anything that is relevant and anything that is happening around us. Of course, if you read, you will know what is happening around you and what is relevant. Go a little deeper and try to read up a little bit more. There are lawyers and practitioners who write about it. Read some of those relevant articles. Educate yourself a little bit more to what is happening around you, because that is what is more important in today's day and age, and that is the readiness that we've all been talking about.
Thank you for giving me the last word. Technology will come. Technology will happen. We are moving much faster than we are to, and never has technology replaced human being. Never. So be rest assured, large jobs are pretty safe. The question is how relevant you will remain to the system, is how efficient or how adaptive you are to the new technology. Disruptions will always happen. There will be, I was telling Anshuman, I think when I started my career, we were on typewriters. It was a typewriter, and you had a queue in front of the secretary to get a draft done. And I still remember a gentleman called BMS Murthy. He used to challenge us, you dictate as fast as you want, I will type it without a single typographical error. And he used to do that. 30 pages, he'll just take out the pages and say, if there's one typographical error, let me know. That used to be his efficiency. Now, come, change, telex, electronic typewriters, computers. I still remember the excitement the first time. I don't know how many of you would even know DOS prompt. DOS prompt used to be a software in which first time we were able to upload a document and I could send it electronically to somebody. That was a big thing for me at that point. Today, you send documents on WhatsApp, right? Documents are going on Twitter and whatnot. So technology will always come. You have to always have, that is what I call being open to change. Nothing is constant, as in life will change, but you have to be adaptive. And the more adaptation that you are willing to do, you will move ahead of the curve faster. It's a one-way traffic. You cannot say AI will not affect me. And today it is AI, tomorrow it will be something else. But please remember, by the very definition of AI, it is artificial intelligence. Today, it doesn't matter when I go to Pranjal or I go to Ruben and I say, Council, I need this view. And when it is signed off by them and it comes to me, I don't care whether they have looked at AI, but if the opinion is not right, I'm going to hold them accountable. And not only them, if I have filed that opinion before a court or a regulator or all of that, I'm going to say this law firm gave me this opinion. And if they are bad, if that is bad in law, they have put their brand on the table, right? So so nothing will replace human intelligence. Please remember that. You have to apply human intelligence, but how smartly you apply to artificial intelligence is important. How, like the same judgments are used by different councils to interpret different parts of the same section. We have seen that in the Supreme Court several times. So it's nothing new. So don't get overawed by what is happening in the artificial intelligence world, what's happening in the technology world. First when ChatGPT came, everybody got worried. Now AI, one step forward, people are getting worried. Nothing is going to happen. The job, and just taking the point from where Sujat mentioned, that will it eliminate jobs? No. The job roles will change, but it will never eliminate jobs. Because what typically, and this morning we were talking, what an A0 earlier traditionally used to do will not do. The A0's role will change. And as I said, keep your eyes and ears open. There are training available. There are ways in which you can learn it for yourself. But if you expect that your law school to teach it, I think because technology is moving much faster than the law school professors can even think. Let me be very honest, we can't think. I never thought 2 years back that there will be something called ChatGPT and artificial intelligence. But it certainly happened, it's happened, and we have adapted to it. The second last point, which I think we spoke for about an hour and a half nearly, But one topic that never got discussed or never was brought attention, thanks to Sonal, ethics and integrity. And it's so dear to me. When I heard the two words, it rang a bell. I said, in a student audience, if we don't talk to you all about ethics and integrity, today in this country or in this world, there is a huge deficit of ethics and integrity. And the world has always changed by people who stood for ethics and integrity. You look at history. Whenever history has changed, the people who have managed to change it were men or women of high ethics and high integrity. I urge this. I speak at various law schools. Sab chalta attitude mat rakhna, please. Go by value system, ethics, integrity. Integrity is not just limited to financial integrity. Integrity is consistency of your delivery of whatever service that you're doing. If you're a lawyer, whether I ask for the opinion or my junior asks for the opinion or my peon asks for the same opinion, doesn't matter. Your opinion has to be consistent. If you look at the dress that I'm wearing or the stature or my designation and your opinion changes on the same set of facts, then there's an integrity issue there. I call that as complete, intellectual integrity, lapse of integrity. Ethics. We all talk about India as a corrupt country. Every corner, nook and corner there's corruption. Who creates this corruption? You pay, somebody pays, therefore somebody receives, right? If you don't pay, nobody will receive it. You pay because you don't have the patience. And this generation, especially Gen Z, you call it, right? Gen Z, which is highly impatient. You want everything to go at a breakneck speed. No, life takes a little time. If you have to go to a government office and get something done, there's a process time. So you have to live by the process time. I remember, and I'll stop with this last example, I used to have a Brit boss, and her name used to be Andrea Coates in American Express. She used to sit in Singapore. And once I went and told her, she says, what's your biggest problem? I said, each of my customer or client says they want it as of yesterday. Everything. They want a FEMA opinion, they want as of yesterday. They expect me to be like a encyclopedia that you ask me a question, I'll answer that. How do you handle that? She says, nothing new. I also face the same thing. But tell your clients, and please, this is not a prejudicial statement. There's some women sitting here, don't get me wrong. She says, and this was told to me by a woman, therefore I'm quoting it. She says, tell your clients, 9 women, 1 month, no baby. 1 woman, 9 months baby. There's a process time for everything. And so therefore, you tell them, you want immediate response? No, you can't do it. You give me the time to review it, then I'll find a yes for you, if possible. But instantaneous answer? No. Because you want an answer immediately, I'm telling you, don't do it. Because I'll play it safe. But that's not the way life should move on. So you have to negotiate with your clients and say, everything takes its own time. And it will take time, it will evolve, and you'll get the right result. And I don't think anybody gets up in the morning, unless you have a criminal bent of mind, that today I will go and I'll be non-compliant. No professor thinks that today I'll go, बच्चों को कुछ नहीं पढ़ाऊंगा, 1 घंटा ऐसे वेला बिता रहा. No, never. Everybody comes with the right intent. While you're walking the journey, sometimes a few mistakes happen. Sometimes, your audience can ask you 5 questions that can topple your thought process. You'll say, okay, I take 2 steps back, come back in the next class and I'll teach better. So please don't doubt the intent of the people, but then at the same time, please remember, nothing can happen overnight. There's a process time, and again I come back to my first point, जिंदगी में थोड़ा ठहराव लाइए, it'll allow you to stay in peace, it'll allow your environment to stay in peace, it'll make you very successful. Thank you.
Thank you, sir, and thank you to the panel. I will now open the session for a couple of questions. It can be either from the students or the teachers. When you ask your questions, please also state who would you like the question to be answered by. So you can raise your hand and we'll take the questions. Yeah, I think we can start with you.
Good afternoon, everyone. My name is Yashotma. I'm a fourth-year student at NLIU Bhopal itself. My question is to Pranjal, sir. So you head a practice of project, energy, and sustainability. And from my understanding, that's A, unconventional, and also B, new. So I wanted to know from your perspective about when you started your field, A, how did you choose it? And since we had a long discussion on evolving to practice areas or evolving to a particular, say, interest. So I want to know how was that experience for you?
So just a small correction, I don't head the practice, I'm part of the practice. I hope my organization is not listening to this. So the aspect of energy law, and Shujat, you can answer this as well. So the first Electricity Act was in 2003, and it's the new Electricity Act rather, and it's been there for a while. I come from a very traditional law school. I went to Campus Law Center, Delhi University. So I had no background of energy law at all. It was only when I did my first internship at Trilegal that I was exposed to that practice area. And from the time I had first interned in 2015 to now, it's been over 11 years, there is a remarkable difference and a journey that this practice itself has seen. So, just to answer your question, it is an area that appealed to me because of the internship that I had done. But personally, I don't think that a college would be able to take that extra mile to teach you these specialized areas of law or evolving areas of law, because every 10-year period, there is a new area of law that develops, or there is a re-emergence of a certain area of law. The biggest concentration has to be on the first principles of law, and as long as your first principles of law are right, you would be able to hold your ground. There is competition law, there is bankruptcy, even capital markets for that matter, are laws that are relatively new, but there are practitioners who have evolved with the legislation itself to be able to build a name for themselves. And that is where I would think that a lot of the focus should lie on. And of course, with your internships, what it does, it gives you a certain exposure to an area of law that you would not otherwise know during your law schools. I know that your college in Manish sir does teach energy law. He is very passionate about it. And so you do have that exposure. Shujat, would you?
Yeah, just to add, in terms of the relevance, and right now if you see the world, there's a lot of conversation on the climate change, the global warming, right, the ESG, as you call it, environment, social governance, the energy laws, renewable energy, and all of these aspects. So from that standpoint, I think the students can always see. I mean, of course, they have to be personally passionate about. One is passion, and two is what the world needs. So of course, there's a book called Ikigai. If some of the students want, they can actually see, because they can actually choose which are the areas which they're more passionate, right? And if that passion and the relevance to the overall world matches, I think then it's a good opportunity to start exploring that. And in some of these new areas which we just talked about, we don't see so many law firms or individuals developing expertise. So that could be one area, and being part of some internship or starting interacting with people who are already working in this stream, I think can definitely help you develop more and start building, your own expertise and your own learning path as well. But yes, same thing goes with the, the AI and technology and all of those aspects, and similar new elements are there. So I think in interactions with people will definitely help, but that's definitely a area to look on, because from a competition standpoint as well, if people do the same stuff also is a challenging. So try to, see what new areas are there, would definitely help. That's just a supplement. Yeah, we'll take a question there, I think.
Just to add one line, I think since he mentioned Ikigai as a book, I'm sure many of you, or rather all of you know, Ikigai, the law firm Ikigai is from one of your alumni, right? And Anirudh Rastogi, who is in this, who also studied here, who's the founder and managing partner at Ikigai Law. I think he set up that firm, which is doing so well, and so happy and proud to know. He was a junior of mine from college. We were in the same firm for about one year, and then he went to Harvard and came back and then started the firm. So, these are the kind of examples that you need to look up to.
So I think we have time for one last question at the back. Yeah, I think the girl in the sari. Yeah, I think we can take a question from you.
Greetings to the panel. As half of the students sitting here are from Tier 2 and Tier 3 colleges, as we are saying, the topic is industry ready. We students are never preferred. We are never the top of the firms, or we are never at the top of NLUs. We are always preferred after the NLU students. Do you think this is the culture that we think is going on? Is the industry thinking about this also? Is NLU students more skilled than us, as we think we are at the same strengths as the NLU students are?
See, earlier I've recruited a lot of lawyers across India. So I'll tell for myself what I have done. I never have any view that okay, you need to pick from this college. So rather than that, what we did in our previous company was to select few colleges. It included Tier 1, Tier 2, Tier 3, and all, and actually make them go through a standard rigor process, irrespective of the CGPAs and all. And there was a proper examination, like an open book exam, which includes a drafting, presentation, and all of those aspects. And based on the performance in that particular, the open book examination, followed by the group discussion and interview, whosoever best were there, we took it. I hope, a lot of other companies are doing that as well. That I can speak for myself and some of the other colleagues. But there's still maybe some of the firms or the companies may have that perception. But I personally feel ultimately the candidate should be good, because when you talk about industry ready, what good the candidate would be, even if from a branded good college and the good CGPA, but if you're not able to put them immediately on the job. That's my thought, but I am sure I can want Sonal to answer that, because that will give the answer.
Yeah. So 2 comments. I was the first non-NLS Bangalore hire by Wipro. Wipro was my first job, so I broke that thing. And when I joined, everybody would ask me, "Oh, are you from NLS Bangalore? Are you from NLS Bangalore?" And I then started telling them I'm from LSC and GLC Mumbai. And then they stopped asking me. So I think it's all about you, It's all about you. So don't carry that in your head. There's no discrimination. So that's my first point. And second point is, when I hire folks, team members, members in my team, I don't look at national law schools alone. I have hired lawyers from across, all universities, Tier 2, Tier 3. So it's all about you, how you, present yourself, what kind of passion, you're driving, and things like that, other points that we discussed. So yeah.
Yeah, I think I'll just add a law firm's perspective to it. Unfortunately, large law firms like CAM as well, we go to national law schools. Not that I support that, but as a firm, and I can't change the institution, they therefore pick. Every year, I think they go to maybe 10 or 12 law schools and hire. So, but that's one part of recruitment. But we also hire through, when we see bright interns, we sometimes give them the opportunity to come back and intern again, and like a callback internship, and then if they're good, they get a PPO. But those PPOs are given to students across law schools. It need not be a national law school. It could be in Bangalore. There is a college called Christ University. I don't know whether you know about it. And there are a bunch of them from Christ University in my office across teams, including my team, and they're doing really well. And there are similar such other examples as well. There are students from Symbiosis, ILS, GLC Bombay, and Delhi Law Fac, and there are so many other non-national law schools. So I don't think there is anything called, in my head today, there is nothing called tier 1, tier 2, and who decides these tiers anyway? I mean, that mindset itself is incorrect. I think the question is not right. So if you belong to a place, that's your place. Be proud of the fact that you belong where you belong. Then it's all about how good you are and how good you have made yourself to be. So don't hold anything against the university where you belong. That's like spitting in your own plate, right? You should never do that. You are who you are and who you make out to be. And it just doesn't matter where you're from. What matters is how good you are and all the other skill sets that you heard from us today. Yeah.
Just adding, a practice that you might see is not a perception, first and foremost. At least I can say this with fair amount of confidence, that industry hiring never happens, never. I worked in different companies where Unilever today has about 120 in-house lawyers. 120 in-house lawyers, Hindustan Lever. Pepsi has about 90 of them. American Express has about 30, 40 of them. So does Match Group, all of that. Never have we hired based on National Law School or NLS. We have said, may the best candidate win. At the initial level, obviously, there are a lot of applications come, and we don't go, because we don't hire every year. Whenever there's a need for hiring, we obviously go to consultants send us profiles. We don't look at that. The initial screening is done by HR, in which they see, culture fitment, this, all that nonsense. After that, when it comes, it doesn't really matter which law school you come from. Are you good? You are not good. And again, I said, you may not be good in law, but you may have the hunger, you may have the attitude. And by the way, at least I am a trained interviewer. I have undergone about some 6 months proper training how to interview people. So we also have certain skills how to assess people. And I've had, and again with no malice, I've had students from Chaudhary Charan Singh University also, which people think, you don't attend classes, you can still pass, but some of the kids are very bright. And we have had people from National Law School also, good. Experience has been good and bad as well. When we hire, there is always, you hire some who are good, some who are not so good, And that's okay, that's part of life. But we don't live with this perception that this particular campus is very good and that particular campus is not good. Otherwise, typical Delhi company should only hire from NLU Delhi, no? Why should they hire from other places? Similarly, in Bangalore, all the tech companies should go to NLS only. Nalsar should dominate Hyderabad. It doesn't work that way at all. It doesn't. And please, you are a young budding lawyers, don't have this perception. You should always think, if I can't do it, nobody can do it. That should be your motto. It doesn't matter which college you pass from.
So I think we'll take one last very, very quick question. Just one last question. I think at the last, she had raised her hand earlier. Can you
Aditi, I don't think you should be asking questions. You already have a job. I think you should not be asking questions.
I'm so sorry. Good afternoon to all the panelists. My name is Aditi Shrivastava. I'm in my 5th year and one of the very lucky people to be hired by Ruben sir's team. I can't help but notice that Sonal ma'am is the only female panelist. And ma'am, you mentioned that you were the first non-NLS person to be hired. Just wanted a perspective from your side, because you must have faced very conventional realities of being a woman in a corporate field. How did you climb that ladder? I'm sure the things are much better now. But what inspiration can you give us, women like me who are just entering the profession? I would love to hear something on that.
Thank you. It's an interesting question. One thing I want to tell you is I've always believed in myself, and I've continuously invested in myself. So when I was doing my law at GLC Mumbai, out of 5 years, 4 years, I did full day internships. So 4 years I've interned, 3 years with Crawford Bailey and 1 year with senior counsel. You know, all my buddies were, college mates were enjoying, you know, they were dating, they were going for movies, they were partying, but I decided to be a little more invested. That helped me. After I joined my workplace, and Wipro was my first job, and I complete 23 years now, not even once I felt discriminated as a woman. The reason being, I was always ahead of the game. I didn't want the gender to come in any way in terms of my work ethics, right? So I think if you're true to your job, if you go that one step ahead in terms of, you know, being updated in terms of what the laws are, how the industry is evolving, investing in soft skills, because, you know, when I started working, I was negotiating a contract with a client in the US, at times a client from Japan, some German clients, so understanding the cultural nuances. And another thing which is very interesting, when I was young, I would tell myself, oh my God, I've picked up a profession, and I was a first generation lawyer, I've picked up a profession, but I'm not aggressive at all. Like, I'm really soft-spoken. I don't know how I'm gonna survive, but this particular trait of mine has worked in my favor, because if you look at our fraternity, with due respect, most of them are overtly aggressive to make their point. I'm the calmest in the room when it comes to negotiation, and I put my point across. So I think just believe in yourself, never think that you're a woman, and just, yeah, be professional, be true to your work, be passionate, focus on your learning curve. I'm also a mother of 2 boys, 19 and 14. I didn't let that affect my career either. It's been a roller coaster ride, extremely difficult as a working mother, and our profession is demanding. But I love my job, and I love what I do. So yeah, never felt discriminated.
I just wanted to add one thing. Like in CAM, where I work, I think about 55% to 60% are women lawyers, and that's just, I've seen over the last 18, 19 years of being in the firm, I've seen that proportion getting better over time. Maybe when I started, perhaps it was 70-30, or and then it became 60-40, and today I think it's the other way around. Almost 60% are women, 55-60% are women, and the rest. So I jokingly say that I think the women lawyers are smarter than the men. At least in corporate law firm, I don't know, I'm sorry, boys, that I'm making the statement. I'm just making a factual statement, and I think sometimes the boys better be careful. I think, I see a lot of smart women lawyers out there as partners in the firm. Most of the practice area heads in my firm are all women. Like whether it is the head of corporate, head of M&A, head of real estate, head of private equity are all women. It's just a matter of coincidence. While I'm making this point, I'm thinking in my head who the heads are. They're all women. I'm sure there is a reason why they're all women. So they give people like me survive with great difficulty. It's not easy.
Thank you for making that point, Ruben. I completely second that. I come from a law firm where the managing partner is a female. The person who heads our practice is a female. And I completely agree with Ruben when he says that women lawyers are smarter than men, because with men there is a certain presumption of an entitlement, and women are always working hard just to be seen. And that often ends up making a lot of difference. And with that, as we close the session, I take this opportunity to thank NLIU on behalf of my co-panelists for inviting us, for greeting us so warmly, and for the lovely hospitality. I thank the Students' Bar Association, the professors, the students, and everybody who has made this a resounding success. I do hope that you're able to take few pointers home that will make you contemplate and think over what has been discussed. Thank you very much.
Thank you, sir, for your words. I would now like to announce that Justice Koteshwar Singh will be arriving in about 10 minutes. So I would request everyone to please have their lunch quickly and return to the convention by 1:05. We will be beginning with panel 4, which shall be chaired by Justice Koteshwar Singh. Thank you. Good afternoon, everyone. I request all the attendees to be seated, and those standing outside are also requested to come in and take their seats. We will be beginning with the panel shortly. I request all attendees to be seated in their places. Our chief guest is arriving soon. लोग कहाँ हैं? I request everyone to rise to please welcome our chief guest. A very good afternoon to our esteemed dignitaries, respected faculty members, and our discerning participants. I welcome you back after the lunch recess, and it is my honor to now begin the final discussion session of the second edition of the NLIU-SBA Law Conclave. Allow me to first introduce the distinguished panel for this session. We are privileged to have with us. We are deeply honored to welcome Honorable Justice N. Koteshwar Singh, Judge, Supreme Court of India, as our first panelist today. Justice Singh was born in Imphal into a distinguished legal family. He earned his LLB from Delhi University. After practicing in the Supreme Court and Guwahati High Court, he became the Advocate General of Manipur in 2007 and was designated Senior Advocate in 2008. He was elevated to the Guwahati High Court in 2011, served as the Acting Chief Justice of Manipur and Guwahati High Courts, and became the Chief Justice of the High Court of Jammu and Kashmir and Ladakh in 2023. On 18th July 2024, he was elevated to the Supreme Court, becoming the first judge from Manipur and only the second from the Northeast to reach the apex court. His judgments reflect constitutional fidelity, procedural fairness, and a humane approach. Among his significant rulings are Dara Lakshmi Narayan versus State of Telangana 2024. A bench, including his lordship, quashed an FIR under Section 498A IPC, observing that while intended to protect women, the provision is increasingly misused for personal vendetta. Vague allegations, if not scrutinized, lead to misuse of legal process. In re-termination of 2 women judicial officers, 2025, the same bench set aside the termination as punitive, arbitrary, and illegal, directing reinstatement and emphasizing that the termination without proper inquiry violates fundamental rights. Directives on POSH Act Implementation Case 2024. His Lordship issued directions for the effective implementation of the Sexual Harassment at Workplace Act, including the appointment of district officers, public availability of nodal officers, and penalties for non-compliance. Through these pronouncements, Justice Singh's jurisprudence balances the protection of vulnerable sections with preventing misuse of law. Sir, your presence is a source of immense inspiration, and we are deeply honored to have you here today. We are also deeply honored to welcome Honorable Justice S.A. Dharmadhikari, Chief Justice of the Madras High Court, as our distinguished speaker today. Justice Dharmadhikari began his legal career in 1992 at the Madhya Pradesh High Court, practicing in constitutional, civil, and taxation matters. He served as the Standing Counsel for Union of India for over a decade and as Welfare Commissioner for the Bhopal gas tragedy victims. Elevated as a judge of Madhya Pradesh High Court in 2016, he was transferred to the Kerala High Court in 2025. In March 2026, he became the Chief Justice of the Madras High Court. His judgments reflect judicial efficiency and humane justice. Among his significant rulings include the Guravayur Employees Union Congress versus State of Kerala 2026. His Lordship declared Section 9 of the Kerala Recruitment Board Act 2015 as unconstitutional, as applied to the Guruvayur Devaswaram Temple, holding that the right to appoint temple staff is an essential component of religious administration under Article 26. Kochi International Airport Limited versus State Information Commission. In this case, His Lordship held that Kochi International Airport Limited is a public authority under the RTI Act, given its government origin, substantial public funding, board dominance by government nominees, and state-acquired land, hence mandating transparency. In the case of Asianet Digital Networks versus Jio Hotstar, His Lordship ruled that the Competition Commission of India can investigate abuse of dominant allegations against Jio Hotstar, even though the broadcasting section falls under TRAI's purview, holding that the competition law enforcement operates independently. In the case of Indian Medical Association versus State of Kerala, His Lordship held that no clinical establishment can deny initial life-saving treatment due to non-payment or lack of documents, mandating transparent trade display, grievance desks, and compliance with Article 21. Sir, your presence is a source of immense inspiration today, and we are deeply honored by your guidance. We are also delighted to welcome Mr. Atul Sharma, Executive Chairman of the Dentons Link Legal, as our distinguished speaker today. Admitted to the bar in 1978, he has built a distinguished career spanning nearly 5 decades, specializing in aviation and infrastructure law. Mr. Sharma is ranked in Chambers Asia's Pacific 2025, listed in Benchmark Litigation Asia Pacific 2024, and acknowledged by Legal Media 360 as a Band 1 practitioner in aviation dispute resolution and project development. Under his leadership, the firm was named Aviation Firm of the Year at Legal 500 India Awards 2024. Beyond practice, Sir has co-authored an article on India's legal opportunities for the Global Legal Post in 2026, reflecting his engagement with legal scholarship. His insights into arbitration and infrastructure law are widely respected. We are truly honored to have him here today. We are also delighted to welcome Mr. Gautam Bhatikar, partner at Phoenix Legal, as our distinguished speaker today. With over 25 years of dual qualified experience in India and England, he is a solicitor of England and Wales and holds an LLB and a BSc in chemistry. His scientific background informs his methodical approach to complex disputes. Sir specializes in offshore maritime and shipping law, insurance, international trade, oil and gas, energy, and environment law. He has successfully represented banks, ship owners, PSUs, oil companies in high-stake cross-border matters. His dual qualification allows him to navigate both common law jurisdictions with ease, making him a sought-after counsel in cross-border maritime and energy disputes. We are truly honored to have him with us today. Can I have a big round of applause for our esteemed panelists? As a mark of our deepest reverence and respect, we now invite our Honorable Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, to extend a warm welcome to our distinguished panelist. I request Honorable Vice Chancellor, Sir, to present a bouquet, a memento, and a shawl to Honorable Justice N. Koteshwar Singh, a jurist whose wisdom and humility have left an indelible mark on the judiciary. I also request Honorable Vice Chancellor, Sir, to present a bouquet, a memento, and a shawl to Honorable Justice S.A. Dharmadhikari, a Chief Justice whose leadership has inspired confidence in the pursuit of justice. I would also now request Honorable Vice Chancellor Sir to present a bouquet, a memento, and a shawl to Mr. Atul Sharma, a legal professional of remarkable insight and unwavering integrity. I request Dean Student Welfare, Professor Dr. Raka Arya, to present Mr. Gautam Bhartikar with a shawl, a bouquet, and a memento. Can we please have a huge round of applause for Sir? The final session that we now embark upon is titled Evolving India's Legal Framework, Rethinking Western Influences and Forging an Indigenous Jurisprudence. India's legal system, including its substantive codes, procedural laws, and legal education models, has been shaped by the historical influences that date back over a century. While these foundational structures have provided stability and continuity, it is time to examine whether they fully align with the aspirations of a modern, diverse, and a sovereign republic. This session seeks to engage in a scholarly exploration of how India's legal framework can evolve to better reflect its unique social, cultural, and economic realities. The panel shall be chaired by Honorable Justice N. Koteshwar Singh, Judge, Supreme Court of India. I now invite our Honorable Vice Chancellor Sir, Dr. S. Surya Prakash, to kindly share his welcome remarks on the subject of this session, setting the intellectual context for the discussion ahead. Sir, please come to the podium.
Good afternoon to all. Chief guest for today's program, Honorable Justice Sri Koteshwar Singh Ji, Judge Supreme Court of India, and Sri S. Dharmadhikari Ji, Chief Justice, High Court of Madras, and Sri Atul Sharma Ji, jurist, and Sri Gautam Bhartikar Ji, jurist, because I am not giving all the details, sir, due to paucity of time. Yeah, already you are known to the circles. And it's my privilege to stand before you and to invite not only the dignitaries, but also the many legal luminaries are there, my learned faculty, and my dear student friends. In fact, the topic shared, that is Beyond Colonial Hangovers, Rethinking and Reforming Western Influence on India's Legal System. Whenever we think of the British, what comes to our mind is their atrocities, how they have plundered, how they have exploited this great nation for more than 200 years. And in spite of all other these negative aspects, one good thing that has happened is that they have given, I consider, a very good, vibrant, independent judiciary. And that independent judiciary, after the federal court transformed into Supreme Court, and that legacy is continuing And today, a common man has faith in the Indian judiciary. That is, even though he may lose faith in all other organs of the state, but everyone has faith in the Indian judiciary and the judicial system. And I'm glad that today we have legal luminaries and jurists and justices who are going to throw light on this area with their long experience in legal field and in the judicial process. So judicial process includes the experience of both the judges and the advocates who are the officers of the court. Here I am reminded to place before you one incident. So whether it is a colonial hangover or whether it is, you can decide it later. So one incident has happened in the Calcutta High Court in 1930s. That was before independence. So the Chief Justice Rankins, he was the Chief Justice, High Court of Calcutta, and one of the youngest judges in the Calcutta High Court was Justice R.C. Mittal. And he was one of the most brilliant and the finest judges of that time, and very, very young, hardly in his 40s. So before independence, getting elevation to the High Court. So the top high courts in those days, they are Bombay, Madras, and Kolkata. Of course, Allahabad also joined later. But these three high courts getting a coveted position as justice in these high courts, particularly for Indians in those days, until a person has extraordinary merit. Otherwise, it was very difficult. So one day what has happened, the juniors, they are trying to place their petitions before this honorable judge. So because the preference is given to the most serious cases and the senior advocates, they used to get the chance. So one day evening, the junior advocates, they went to Honorable Justice Mittal and requested him, sir, you please give some time for us also, because we also have certain matters, etc., etc. They pleaded. And Honorable Justice Mittal, he was kind enough, said that, okay, 11 o'clock onwards, I have to take the matters of the senior advocates. I will do one thing, I will come 1 hour before. I will occupy the bench at 10 o'clock. So first I will give time to you, and I will listen to you, and then I will go for other matters. And they were happy, and next day, the junior advocates, maybe 5, 10, whatever may be the number, they came, and they have been waiting for the Honorable Justice. So somehow, this appointment has slipped from the memory of Honorable Justice Mittal. So as usually, he came at 11 o'clock and he occupied the bench. And when he occupied the bench, then he saw the junior advocates, they have been waiting for him for the last 1 hour. Then he realized that he has given an appointment to these young fellows. And the same day, he put up his papers saying that a person with failing memory should not sit as a judge. And Justice Rankins and others, they tried to convince him. So this is a small and trivial, so you need not bother. So just you, of course, Honorable Justice has given the apology for not keeping the time, but Justice Mittal, he didn't accept. So I should not. And the same day, he demoted his office. That was the legacy. Whether, I am not here to judge whether the act is good or bad, or rational or irrational for the small thing. But that was the highest level of what you may call it commitment or integrity. Of course, it has nothing to do, but the level of commitment, that's the kind of judiciary that the Britishers has established in this country. And those who are interested, you may go through, there is a book, Indian Judiciary by Pannalal Dhar, where he has quoted this. And there are also other incidents of where the Indian judges, they have amplified their highest level of integrity, not only before independence, even after independence also. We have so many judges. Justice B.L. Hansaria, Justice Mukherjee, and there are so many judges, right from Patanjali Shastri to from Madras High Court, from Bombay High Court, even from Justice J.S. Verma, Justice Venkatachalaya. There are wonderful judges, those who have contributed extraordinarily for the development of jurisprudence, particularly the constitutional jurisprudence in this country. So this is one instance. How? I'm not speaking that all the British, they have done all good things to India, but even the devil should get its due. This is the one area where the Britishers has given us a wonderful system. And in these few words, I welcome all the dignitaries on the dais, so we will have a fruitful discussion, and definitely for the young generation. And you know, even Bankim Chand Chatterjee, he was also a judicial magistrate. He was also a law graduate from Calcutta University. So there are so many before independence. There's a long list. And there are so many episodes of honesty, integrity, and where they have sacrificed their lives, they sacrificed their practice, and also the positions. So with these few words, let us join for the wonderful discussion. And definitely this session is going to enrich all of us. And thank you, sir, for sparing your time and coming to NLIU all the way. Thank you once again, sir. Jai Hind, Jai Bharat.
Thank you, sir, for your words of wisdom. I now invite our esteemed panelists to commence their deliberations. The floor is now open for discussion. I invite Justice N. Koteshwar Singh to kindly address the gathering.
Honorable Justice Dharam Dikari ji, Chief Justice of Madras High Court, Professor S.P. Singh ji, Vice Chancellor of the University, and Atul ji, and Gautam ji, who are here on the dais, and off the dais, the faculty members, counsel, lawyers, and my dear students. This is a subject which I have been thinking over for quite some time. So it's a continuing process for me. As a student of law, of course, this is not really any subject of subject of discussion in our law schools, in our law colleges. And I don't think it is also, except perhaps in the post-graduation, maybe. But in course of my career, apart from reading law books, I used to read on various scriptures, Bible, Quran or something like that, and Hinduism also. Hinduism is not religion in that sense of term. Advaita, something which fascinated me. See, one thing that there's a very logical exposition of the thought process, the philosophical thought process. And I was reading a very interesting debate. Most of you perhaps might have learned also debate between Shankaracharya and Madan Mishra. In earlier times, there used to be a lot of discussions and debates on philosophical aspects of life. And person or a group who would lose would become a disciple of the winner. That's how the tradition used to go on. So I used to wonder, in that case, such a rich tradition of discussion and discourse, there must be rules also. It can't be just haphazard kind of discussion, arguing across the board. There must be proper rules laid down. I tried to understand. I came across this in Mimamsa also. And incidentally, I came across the judgment of Justice Karju also. He discussed about Mimamsa principles. I said, yes, there is something why we have not studied this. Perhaps the time to look into this. Why? It's not that there is something seriously wrong with the modern legal system we have. In fact, we have the Constitution before us, one of the most creative legal document. It's not merely a legal document. It's a historic document. It's a social document. It is a constructive document, and it lays out the vision, the ideals which inspired this country to become independent. How do we go about, how do you go forward? The vision. So it's about the visionary, creative, how to change the society. In course of these thousands of years of civilization, we had faced various problems, introduction of various alien concepts, practices, cultures, which has indeed become a part of this country also. How do we go about it? So it provides a very, very creative manner in which the society, which is now a very pluralistic society, can progress. But then coming to the topic, because time is short, because there are other speakers also, I don't wish to go much in detail. The topic today, which is subject matter of discussion, is beyond colonial hangovers, rethinking and reforming the Western influence on India's legal system. But how do we reform ourselves? Is there anything we can go back? That's also important. We've said that, oh, this land of religion, land of superstition, the West has given this image of India as civilization, snake charmers, land of elephants. Of course, when the colonial powers conquered, India was devastated. India, which was one of the richest countries in the world 1,000 years before, became one of the poorest in the world. It was not richest in terms of economic achievement, but in ideological, philosophical achievement. I don't think there is any other philosophy which is as evolved as Indian philosophy. Indian philosophy is something which is all around us. It's nothing something called a subject to be studied. It's part of our lived experience. That's how Indian philosophy has evolved. It continues to guide us. Why do we go back? Do you think we can go back? I was just trying to find out, if we go back, do you find something on which we can rebuild the contemporary legal system? Yes. As students of law, of course, we all are aware of discourse. Moot court competition is a very frequent activity in the law colleges. Very interesting, there's a story of Sulabha. She's a very learned female ascetic. She's mentioned in Mahabharata. And there is also, during that time, ancient king philosopher Janaka. Janaka was considered to be one of the greatest philosophers as king. He was very fond of these discussions, and he used to invite all these learned people, sages, rishis, all intellectuals, and have discussion, learn. So there was this discussion between her and Janaka. Of course, I can't go detail in that, but very interesting thing what she has made. She mentions that in an assembly of intellectuals, the statements made by debaters should reflect the following 5 qualities. What are they? Soksma, subtlety, fitness. Shankhya, listing out the points of debate. Krama, the order, logical flow of arguments. Nirnaya, decisiveness. Prayojana, clarity of the purpose of the debate or discussion. A very scientific way of approaching a debate. As I mentioned earlier, is not just coming and sitting and shouting at each other. There's a proper line of how you should walk it out. And she also mentions the flows of expression which a debater must avoid. What is that? I will not go into the Sanskrit words to cut short. Verbosity must be avoided. Don't use complex sentences in arguments. And be true. Avoid untrue statements. Why? And don't say anything which is opposed to the 3 basic purposes of human life. As we know, on Indian society, culture, the 3 are very important: dharma, artha, kama. Don't say anything which is opposed to this, because these are basic elements of a proper existence of human life. Don't use uncultured or ungrammatical language. And don't be too brief also. And don't use an arrogant tone that I am the best speaker. And don't use incomplete sentences or ambiguous or without reason. Whatever you say should have some reason behind it. And also, she mentioned that while making a statement, one should not be affected by the following emotions. What are those? Don't think of kama, krodha, bhaya, lobha. See, self-pity, disgrace, shame, pity, arrogance. These are aspects a debater, a speaker must always avoid. A very interesting statement she makes also. During the course of a discussion, when the speaker, the listener, and the words spoken agree with one another without conflict, then the meaning of the discussion is very clear to everybody. So these are something, when we fall back, they are something which we learned. Of course, these are taught. I'm sure the teachers teach you how to perform in a moot court, but things are already there thousands of years before. Yes, and there is another very interesting school. And there are 6 philosophical schools of thought in Indian philosophy. Nyaya is one of them. Of course, Mimamsa is another. I'll be discussing a little bit on that, keeping my time constant. Nyaya discusses various methods. I will not go in detail. For example, it refers to how knowledge is obtained. Classifies 4 classes. Pratyaksha, direct perception. They are all relevant to Indian Evidence Act also, because what is admissible is your direct knowledge, not hearsay evidence. So how do you learn also? Through direct perception, pratyaksha, or seeing. And how do you learn also? Anuman, you compare, you inference, Anumana, you inference, you assume on a basis of certain accepted thing. Then upamana. Upamana, you compare with what is already in existence. Very, very interesting. I will not go into that detail. I just mentioned these aspects just to give an idea that already there is a science of knowledge in existence, which perhaps, I know this is now subject being taught at least in some of the postgraduate level. I've seen some articles by law students on Mimamsa and all this Nyaya philosophy, but it has not really caught up. And this is something that we lawyers and judges are ill-equipped, not because we don't have the basic knowledge, but we just don't have the time to do this research. It requires three things. Knowledge of Sanskrit also, because most of these philosophical treatises are written in Sanskrit. So unless you have a good foundational knowledge on Sanskrit, and if you rely only on the translated version of Sanskrit, then you may have a problem. But there is huge issues also in today's Indian discourse. Translations of Indian scriptures by foreign authors, how truly they reflect. So there is a whole debate going on also, this Oriental versus. So the knowledge, the source of knowledge, unfortunately what has happened in India is that many of the scholars have remained tied to Indic scholarship. They have not gone beyond that. There's a difference also. I've seen some of this in popes in Italy. They have a huge library also. And the scholars, the monks, they don't study only the Bible in Latin or whatever. They study Hinduism, they study Jainism, Islam, and try to read the original versions also. So what happens is that then they start explaining what Hinduism is all about. They start explaining what all Islam is all about, but from their perspective. So this is something which I feel there is a deficiency which needs to be looked into by especially the law college university, the researchers. They need to delve down and rediscover these rich resources we already have. Otherwise, we wouldn't have attained this. The whole concept of zero, we all know, started from here. It just didn't come that's floating from the air. There were researches done. It is not just Shloka which produces the concept of zero. Aryabhat, the great mathematician, he just didn't do meditation and discover something great. There was a whole course of study, how much we have done that. Therefore, something which needs to be examined when we discuss about this, reforming the Western influence of Indian legal system. We all students of law are familiar with preamble, but I'll be surprised if all of you know. Yes, anybody who can recite preamble, law student? Any law student, can you recite preamble with me? Yes, preamble. We the people of India? Yes, we the people of India, having solemnly resolved to constitute India into sovereign and to secure to all its citizens justice. Thank you. Now, please, my request to all students, this is something which I tell all the law colleges, all the students, you must remember this, because this is the foundation of our constitution, the foundation of our life. India with this vision, we cannot progress ahead. And we said, See, liberty, fraternity, equality. This is something, these words have been derived from where? French Revolution? Yes? Is it correct? Yeah, please tell me, is it French Revolution? Sorry? French Revolution. Partly correct, not fully correct. It was already there before French. When Europe was in dark ages, India had already attained the height of civilization. When the first Roman temple in Jerusalem was attacked, the first Jewish temple was attacked by the Romans, many of the Jews fled Israel. Some of them came to India. Do you know this fact? 5th BC, I think. The Jews came to India during that time. And again, when the second temple, the Jewish temple, was again attacked by the Roman, 7th AD, I think, there was again a wave of migration of Jews. They came to India. You please go to history and read about the Jewish immigration in India. The first synagogue is there, still in Cochin. Some of you who have been there, still there. And the Jews came, well, they were accepted, isn't it? Were they persecuted, were they imprisoned and converted to Hindus or no? They remained Jews. They continued practicing their faith belief. When Persia was again invaded by the Mughals, I think from Arabic, then Persian Zoroastrians, they also again fled. They came to India with their practice, with their religion intact. They were allowed to stay there, isn't it? That's part of history. Again, I'm talking of then BCs. Even the Muslim, we think that the Muslim came to India after the Mughals. No. There was already a sea link, sea trade between this Malabar and the Arabic Peninsula. There used to be a spice trade. They were already there. They were settled in India. So what does it signify? 3 things. Liberty, because they were never imprisoned. Equality, because they were treated with they were treated at par. They were not discriminated. Justice, they were not denied justice. No injustice was caused to them. So these ideas, we think that we have borrowed from French Revolution. If we go back to our own tradition and history, we say that these ideas are already there. Only thing that we have not been able to see this because of the Western education we have. I am nothing against Western education. I am myself a product of that. But a time has come to see beyond that, because the Western legal education system cannot perhaps deal with all the situations, contemporary situation in India, because India remains basically Indians. Except for those who are able to go out abroad, study, come back, fine. But 90% of the Indians remain in India. 90% of the cases in India are still in the rural areas. Out of 100, I think 4.4 crores cases pending, 80% of the cases are still fought in the district courts, where people still live with their traditions in their mind. How do we reflect to their needs and requirements? Therefore, from that perspective, perhaps, this topic is important. How do we shape ourselves, our legal system? Yes, there have been already changes made. The Constitution itself is a big leap, a foundational document. The preamble provides that in our part 3 also. The freedom of speech, liberty, the liberty, the rights of the minorities, rights of the fundamental rights of minorities to retain their culture, the language, the religion. There are very few countries in this world, if you read the constitutions of the countries, other worlds, they subscribe to a particular fate, that this is a Christian state or this is a Islamic state. There are very, very few countries which subscribes to all the religions like India. India never declares itself to be a Hindu state. In fact, the word Hindu itself is a word used, ascribed to this country by others, foreigners, people who stay beyond Indus. When the Greek came, they found all those people who were staying behind this country, behind the Indus River, the Hindus. So it didn't have any relation to the religion. By the time Greek came, there was already Buddhism, there was already Jainism, there was already Hinduism flourishing in this country. So this question to these Hindus does not mean anything, as far as my understanding is concerned. There may be people who may not agree with me, but the Hindu doesn't denote anything. Hindu simply is those who has been staying beyond Indus River. But we had our own culture, traditions. So I was coming to that, why it is relevant. Mimamsa, one of the, this again, 6 schools of philosophical thought schools in India. Mimamsa is very important, which again, very interesting. When I went through this Mimamsa philosophy, I will not go again in detail because again, there are those who are not initiated in this study will find it a little bit boring, especially in second half, isn't it? After you have eaten your meal. So I don't want to make it more boring by reading out all the Sanskrit text and the words. But broadly, interesting because, why I say, because it connects to the kind of study, the kind of approach we adopt in studying law. Because law is essentially based on logic, reasoning. Anything which is irrational does not have a space or place in law. So how the Mimamsa has approached? Very interesting that Mimamsa, according to Mimamsa framework, there are certain basic frameworks of procedure, very important, how to study. That there must be, first of all, there must be a subject to be interpreted. First of all, there must be an existence for what all this discussion taking place. Then obviously there must be doubt also. That's why we discuss. If there is no doubt, if there is no ambiguity, there is no question of discussion. Then also another issue is that then everything must have a prima facie kind of appearance, postulate. Okay, this looks like morning because suddenly the sky has become dark. So looks like a morning. So prima facie it looks like a morning. Then there must be another counter to that. Answer, counter argument, response. Then you come to a conclusion. So what I'm trying to say is that Mimamsa, this theory, consists of these 3 basic postulates. That's what we do in law also. There is certain premise which is correct, not correct, there are arguments, counter-arguments, then you come to a conclusion. This is already there. We have already an evolved system. Then very interesting, law of interpretation, all was Maxwell interpretation, various laws of interpretation, we are so well aware of. Indian system also had this kind of interpretation. How do you do that? I mean, when I read out, it will look as if, oh, these are all we all know. For example, I just say, one of these is that Jaimini is one of the greatest philosophers in this school of thought. He lays down this number of principles, axioms. He says, every word and sentence must have some meaning and purpose. Does it sound very familiar to us? Sounds very familiar to us. And he says, any interpretation which renders a provision nugatory or obtuse is a faulty. You should not accept that interpretation. Then he says, where there is one rule or proposition would suffice, not more than must not be assumed. There is no need. If it suffice, if one interpretation itself is satisfactory, don't go for more than that. Consistency of interpretation of the same words also necessary, unless there is a special reason to do so. There is another very interesting axiom which has been used extensively by Supreme Court also. I will refer to that one judgment, I will not take much time. Guna Pradhan. Very interesting. When the subordinate ancillary idea purports to contradict or is in conflict with the principle, the ancillary should be interpreted in such a manner the principle remains, or the ancillary should be discarded altogether. See, law of interpretation, again, we have read this also. We also know the harmonious construction also. That's also discussed by Jaimini thousands of years before. What he says, contradiction between words and sentences is not to be presumed where it is possible to reconcile them. And in case of real contradiction, one of the options can be chosen. So these are, see, they have been whole, because there were, the whole schools of this Mimamsa was brought in when, because there are many words, Vedas. Vedas are written very short form, few words. So sometimes there has to be confusion from what it followed, subsequent Vedas. No? So there has to be how to interpret. So these all principles of interpretation was evolved at that time, which actually gels with our present practice we are doing. Again, I will not go much in that. Then there also he has called, see, legal maxims. It is said, a word can be shown to throw light on the preceding as well as succeeding clause. Very interesting. The special law prevails over general one, which corresponds to our, you see, the legal Latin maxim, generally a specialis non derogant. But already he had spoken long time back. Sometimes I wonder whether these Latin scholars really came to India and studied. In fact, there is a possibility. What has happened is that, see, Buddhism also has adopted many of these principles of Mimamsa. Buddhism had spread only up to Bactria. Bactria is the present Afghanistan. Gandhar, in Mahabharata we said Gandhar Raja, the Gandhar place, Kandahar, what we know today. So all this, the Buddhism had gone, and is not very far off from the Eastern Europe, Roman Empire. So there has to be collation. Then the Islam, when Islam also rose this golden period of Islam, there was a lot of discussion at that time also. So I have a feeling that they might have adopted many of these Indian treatises, philosophical treatises, which later became part of their philosophy. In fact, it was recognized by the British themselves. Many of the students of Indian legal system would know a very famous case called Beni Prasad case. Beni Prasad versus Harday Bibi. It was decided in 1892 by Allahabad High Court. The question arose when, because under Indian adoption law, if the lone son, he cannot be adopted. But it was adopted there. The question was that how can he the validity of that adoption was questioned before the court, High Court. Then one of the British judges, he was the Sir John Edge. He went in detail into this Indian legal system. In fact, invoked Mimamsa also. There were a lot of interpretation among the Hindu scholars. Then he came, based on Mimamsa philosophy, treatises, principles. He said, yes, under the customary Indian laws, adoption of a lone son is not appreciated, considered sinful, not appreciated, not recommended. But he says there is no edict which says it is illegal, it is not permissible. Therefore, he says, even though it is not desirable, since it is not prohibited under the Hindu law, following the Mimamsa principle, he said, yes, will not hold this adoption invalid. This is one, that was 1892. Thereafter, of course, the British confined only to interpretation of the personal law. They did not go in his criminal law side and other civil matters. That was based on because they came to do business to make money. So whatever was comfortable to them, the legal system was comfortable to them for enriching themselves, they had applied. For example, see, when the British came, many of these communities, they were treated as criminal gangs, the tribes. It is just pure colonial mindset. There was nothing called criminal tribe in Indian context. I'll just refer just one more before I wind up. That very interesting, the Guna Pradhan, that judgment which was referred in that, this is in Justice Kaju has made an exhaustive reference. I'll just read one paragraph of that. In Ispat Industries versus Commissioner of Customs, 2006, volume 12, SCC 583. He mentions about, now he refers to Sabar Bhashya, translated in English by Dr. Ganganath Jha. The sutra says, it says that where there is a conflict between the use and the substance, greater regard should be paid to the use. He further explains, when there is a conflict between the purpose and the material, the purpose is to prevail. That is purposive, interpretation. Because in the absence of the prescribed material, a substitute can be used. He goes on to give the example. This is by Jaimini, the philosopher. He gives the example, the prescribed yupa, that is the sacrificial post, for tying the sacrificial animal must be made of khadir wood. However, khadir wood is weak. While the animal tied may be restive, may be stronger, so it may break. Now, this substitution, instead of this khadir, they use kadar wood, which is a stronger. Now, this substitution is being made despite the fact that the prescribed wood is khadir as per the injunction. Vedic injunction, you should use khadir wood. Now he says, now this substitution is being made despite the fact that prescribed wood is khadir, but this prescription is only subordinate or accessory to the performance of the ceremony, the yajna. This is what is important, which is the main object. Hence, if it comes in the way of ceremony being performed, it can be modified or substituted. Now, the same was used in various numbers. I will not go much in detail. Just to highlight that when we go back to our own, try to discover, yes, there are gems to be discovered, waiting to be discovered, especially our legal community. The knowledge is still confined to Sanskrit scholars, Pandits. But I think time has come for the legal community to go deep into this. And perhaps it may provide a better way of explanation of the problems we face in our system, which is immediately acceptable to us, because if it is indigenous to us, if it belongs to us, acceptability becomes much easier. Because if we express, if we solve the problem in the language, in a manner which has been done in our country, in our system, in our tradition, the acceptability will be much better. Because this is the biggest problem in India. Because, see, I am not a scholar, I am not an academician. From my experience, what we have seen is that the litigants, the common man, they get very, very put off with the language we use in the court. The lawyers will use the Latin words, res judicata, ipso facto. He doesn't have a clear idea what is this. I know this ipso facto, all this. We love to speak in Latin words, use all these verbose, Latin words. In judgments we write. Judgment for whom? Judgment is the answer to the problem posed by the poor litigants. He wants the answer in the language he knows, understands. Unfortunately, our Indian legal system has worked in such a fashion because this power of attorney is a very big concept in India. Power of attorney is, I give my all authority to you. Whatever you do, I accept it. The whole concept of power of attorney. Now, in the name of the power of attorney, so we do all kind of activities and exercises and use the languages which is absolutely not understandable to the people. So there is a gap between the institutions and the people for whom this justice delivery system exists. So it's a big challenge for us. Fortunately, we have made a lot of changes. We encourage the court proceedings to be in the local language. If it is in MP, we always encourage the Hindi, or if you are in Tamil Nadu, Tamil, whatever it is. Because they are able to connect with the system better. So if you are able to connect with the system better, if you are able to connect through the medium, through the language, through the expressions, which they are used to for thousands of years, perhaps it may provide a better solution to the problems we face. So from that context, this topic, though not be of immediate relevance to the law students who are passing out, but I think has an importance in the long term. I think I have taken much of your time. Yes, because this is something very, very interesting. That's why I immediately also accepted when I was requested that is a very interesting topic. I said, fine, I would like to, yes. And interesting, in India, see, if we study our Indian literature also, I came across a very interesting article on how this freedom of expression, there was a Natya Shastra, it was written by Bharata, about, it is a 17th century, I think, Natya Shastra, he was written. So he talks a very interesting incident. At that time, of course, there was no cinema, there was no TV. So the Natya was the medium of entertainment. So there was a drama called Amrita Manthan, the churning of the ocean. And in that, the demons were portrayed in a very bad light. So the demons who were sitting in the theater, like here, they got very upset. They got very angry. I said, you are portrayed as in such a bad light. They threw the chair, table on the stage also, no? Then, of course, then the men handled the actors also, disrupted. They said, this is not the way. Then Indra and Bhagwan, so देवता लोग अरे शांति क्या भाई ये सब मत करो धमकाया भाई ऐसे नहीं करना है then they are very unhappy दानव कहते हैं ना, दैत्य दानव, तो देव भेजा नहीं, चलो अभी ब्रह्मा जी के पास चलते कंप्लेन करने, सुप्रीम कोर्ट में जाते हैं। ब्रह्मा जी के पास गए तो ब्रह्मा जी बोले क्या हुआ भाई, इतना गुस्सा क्यों है? तो देखिए ना क्या क्या नाटक दिखाते हैं हम लोग को, दे हैव शोन इज इन अ बैड लाइट। तो ब्रह्मा जी ने कहा, ये तो नाटक ही तो था, उसमें क्या इसके ऐसी क्या बात है, तुमको एक्चुअली तो कोई डैमेज तो नहीं हुआ है, ये नाटक में हो सकता है कि आपको भी ये मे पुट यू इन अ वेरी बेटर एंड देवता इन अ बैड लाइट ऑल्सो, जस्ट आर्ट, जस्ट एंजॉय सेट द सेक ऑफ आर्ट, you know. Why I reminded of this because in today, see, we see all kind of defamation cases coming up. The tolerance level has gone down so much. But this Natya Shastra of written about 16th, 17th centuries, it gives a glimpse that the tolerance we must learn in spite of all this criticism in the field. So, thank you very much for giving me this opportunity to share my views. But thank you so much.
Thank you, sir, for those words of wisdom. I now invite Honorable Justice S.A. Dharmadhikari to kindly continue the discussion and grace this podium. Can we please have a huge round of applause for sir?
Honorable Justice Kotishwar Singh, Judge, Supreme Court of India, Surya Prakash ji, Vice Chancellor, NLIU, Atul Sharma ji, Gautam ji, and all the distinguished guests and dear students. Beyond colonial hangovers, rethinking and reforming the Western influence on India's legal system is a topic of vital importance. As we all know, the Indian traditional legal system was deeply rooted in its cultural fabric, reflecting the values, beliefs, and customs of its diverse communities. Justice was not merely a legal concept, but a moral and social obligation intertwined with religious and customary laws. Dharma formed the center of this system, which incorporated righteousness, duty, and justice as key principles for preserving social order. The pre-colonial legal system was a mirror of diverse cultures in India, which relied on harmony, duty, and social coherence with Hindu Dharma Shastra, Islamic Sharia, and indigenous tribal tradition as its tenets. Our indigenous mechanisms of dispute resolution were largely community-driven, with panchayats, caste councils, and religious authorities playing a central role in administering justice. These focused on reconciliation and restorative justice, ensuring that legal decisions aligned with societal values and traditions. Dharma is the foundation of all. Upon Dharma rests the whole universe. Therefore, Dharma was a universal principle that bound both the ruled and the rulers, not just a set of rules for behavior. The legitimacy of the king was based on his adherence to Dharma, which is the duty of upholding justice, truth, and welfare. The king was never the source of law, but rather its servant. This ideal is eloquently expressed in the Mahabharata. The law is the king of kings. Even the king must obey the law. The king was seen not as a mere ruler, but as a protector of Dharma, whose legitimacy depended on his adherence to righteous governance. concept of justice, nyaya, social duties, restitution, and arbitration were not only well developed, but deeply spiritualized. However, with the onset of British colonial rule, this organic legal tradition was systematically dislodged and replaced by a codified adversarial and foreign jurisprudence. Yet, even amid colonial disruption and post-independence legal modernization, the essence of ancient Indian legal wisdom did not vanish entirely. The Constitution of India, though a document of liberal democracy and modern law, still resonates with echoes of its philosophical ancestry. Principles such as equality, samanata, secularism, dharma-nirpekshata, and justice, nyaya, may be framed in contemporary language, but they carry the spiritual legacy of centuries past. While British colonization standardized and modernized legal principles, it marginalized indigenous justice traditions. Judiciary has never ever since been working to balance Western influences with India's socio-cultural realities. The primary criticism of the existing legal framework is that even after more than 75 years of independence, it remains rooted in the Victorian era. The Indian system relies on the British adversarial model, which is criticized to be slow, expensive, and encourages victory over justice. As we reflect on our journey as a sovereign nation, we must ask ourselves whether our existing judicial structure is truly achieving the scope of justice for the people of Bharat while protecting their indigenous culture and heritage. Rethinking and reforming the influence of Western law in India is not about erasing the past, as the existing structure provides the backbone of India's democracy. What we should deliberate on is decolonizing the mindset of the legal institution. In MC Mehta versus Union of India, 1987, 1 SCC 395, a constitution bench of the Supreme Court observed that we cannot allow our judicial thinking to be constricted by reference to the law as it prevails in England, or for the matter of that in any other foreign country. We no longer need the crutches of a foreign legal order. We are certainly prepared to receive light from whatever source it comes from, but we have to build up our own jurisprudence. The Indian judicial system, as we know, is largely a product of colonial legacy. Even after independence, much of our legal framework, procedures, and mindset continues to reflect British influence rather than Indian realities. One of the major issues with the present system is its complexity and inaccessibility. Legal language, procedures, and formalities often alienate the common man, especially those from rural backgrounds. Most of our laws are written in complex, anarchic English. When a farmer in a remote village in Tamil Nadu or Madhya Pradesh enters a courtroom, he is essentially a spectator in his own life's drama. If the litigant cannot understand the reasoning of the court, then justice has remained locked behind a colonial gate. Primarily, the movement for Indianizing the Indian legal system is directed towards integrating the virtues and values of the ancient Indian legal system into the contemporary legal system. Furthermore, Indianization requires a shift from a purely right-based approach to a balance between rights and duties, which has been a cornerstone of traditional Indian thought. Our procedural laws must pivot from a culture of adjournments and delays to a culture of efficiency and empathy, and we must bear in mind that justice must be swift to be meaningful. The Western model is primarily retributive, focused on punishment. We must look back at our roots, the panchayat systems, and community mediation to emphasize restorative justice, reconciling the victim and the offender is often more valuable to society than merely filling prison cells. To resolve the dispute without destroying the relationship between the parties is of greater significance. For instance, the concept of Lok Adalat is a modern revival of our ancient Panchayat system. Instead of fighting for years, parties sit together to find a middle ground. India has a rich history of local conflict resolution, Panchayats and Lok Adalats. We consider arbitration and mediation as modern legal trends, but it is a fallacy as India has had a thriving culture of Gram Sabhas and Kula Panchayats. Strengthening these as formal, legally binding alternatives to the adversarial court system can reduce the massive backlogs of cases. This is more so because arbitration allows parties to set their own timelines and mediation allows for win-win situation where relationships are preserved. We must also bear in mind our ancient religious text recognized privacy as a right, and in case Puttaswamy versus Union of India 2017 10 SCC 1, the Supreme Court observed that even the ancient and religious texts of India, a well-developed sense of privacy is evident. In Joseph Shine versus Union of India 2019 3 SCC 39, a judgment pertaining to decriminalization adultery, the Supreme Court referred to the Manu Smriti, which prescribe punishment for adultery. The recent replacement of the Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act with Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Saksha Adhiniyam is a significant move. The intent is to move from a punishment mindset to a justice mindset. The three new laws repealed the colonial era criminal laws. This legislative move is pitched to be watershed movement in the process of decolonizing the Indian laws. It is pertinent to note that the statement of objects and reasons clauses of the three new laws clearly mention the legislative intent to decolonize our existing criminal system and shun our colonial identity. In a symbolic break from its colonial past, the Supreme Court of India has unveiled a designed statue of Lady Justice. Though traditionally, Lady Justice is depicted wearing a blindfold, symbolizing impartiality and the idea that the law is blind to wealth, power, and status in the new design. The blindfold has been removed, emphasizing that the law is not blind, it sees everyone equally. The removal of the blindfold signifies a shift of judiciary's evolving identity, one that acknowledges the need for awareness and sensitivity to inequalities in society rather than blind impartiality. Yet another significant change in the replacement of the sword, which traditionally symbolizes punishment and authority, with the Constitution in Lady Justice's left hand. This redesign emphasizes that justice in India is now rooted in constitutional principles rather than the exercise of power or force. The Constitution, as the guiding document, underlines the importance of legal frameworks in delivering justice. Meanwhile, the scales in her right hand, which remain unchanged, continue to symbolize fairness and impartiality in the judicial process. With her eyes open and the Constitution in hand, the new statue stands as a symbol of justice system focused on fairness, equality, and transparency. The removal of the colonial era blindfold and sword reflects a judiciary committed to upholding constitutional values and addressing the social and legal inequalities that persist in the modern society. Then by embracing virtual courts, we broke the physical barriers of accessibility that was prevalent in the past. We are not just fixing an old system, we are building a new one that is bringing the courtroom to the village rather than forcing the villagers to go to the city. A notable development towards Indianization of the legal system has been an introduction of Vidik Anuvad software, SUVAS, by the Supreme Court of India. It is rightly celebrated as a concrete step towards Indianization of the legal system in its sense that it enhances the accessibility of the courts with the objective of promoting regional languages in judicial procedure. The machine-assisted translation tool SUVAS, which is trained by artificial intelligence, has been put to use. It translates English judicial documents, orders and judgments into 10 vernacular languages, that is Hindi, Kannada, Tamil, Telugu, Punjabi, Marathi, Gujarati, Malayalam, Bengali, Urdu, and vice versa. Similarly, the recently launched Tele-Law Scheme 2 aims to provide legal advice and representation services to over 50 lakh people in India under the Nyaya Bandhu Pro Bono program. This single registration gateway shall provide common citizens with legal advice, assistance, and representation in one. It is a commendable initiative. Practices such as addressing judges as lordships or ladyship and the highly formal courtroom environment reflect a system designed during colonial times, where the common citizen has to plead for justice rather than claim as a right. This system prevails despite specific directions that judges need to be called in a respectful and dignified manner, and it is not compulsory to call them my lord or your ladyship. Before parting, I would refer to the opening words of our preamble, "We the people of India," which reflects the Buddha's declaration that a person is their own master and must build their own future. The framers used this to emphasize that the people of India are the true masters of their land. Justice in India should be a gift from the state to its subjects. It must be a right exercised by citizens in a language and a manner they truly own. Our law schools must integrate the works of Indian thinkers and the principles of Nyaya and Dharma into our core curriculum. Our goal is a legal system that is Indian in soul, modern in outlook, and universal in its pursuit of justice. Incorporating concepts of Dharma and Nyaya into modern statutes does not mean replacing secular law with religious law, but rather grounding the interpretation of statutes in Indian social realities rather than British precedents. It is necessary that a separate dedicated course on Indic sciences, Indian culture, long enduring values and traditions of thousands of years, which have sustained the spine of Indian civilization against any and every onslaught, allowing it to attain permanence, must be incorporated mandatorily in the curriculum of all the law schools. Stories of Panchatantras, Jataka tales, lectures of Chanakya, discussions and preachings which Ashoka received under adopting Buddhism, which have mirrored in various parts of our Indian constitution, all need to be taught necessarily to the young law students, especially in premier NLUs of the country. We are increasingly witnessing that though NLUs are producing prodigies who are way ahead of their contemporaries, the drawback is that they are graduating with the ultimate aim of becoming millionaires at the fastest pace. Majority of them have a complete disconnect from their cultural and ideological roots, be it the principles of Jainism, Buddhism, Manusmriti, or Arthashastra. The correlation of all these texts and rich literature must be necessarily known to all the law students. They will not only bring stability and maturity in their thinking, but also make them enlightened about the great organic Indian culture of being extra conscious of our duties and karma for which we are born in this great country as a human being. The time is not far when premier law schools may be successful in producing intelligent graduates, but thinking like robots and not like human beings with the sensitivity they ought to nurture and develop for serving the common man of the society. All of us have consciously chosen this noble intellectual professional, not for becoming the rich class, but respecting the promise that rule of law always acts as sentinel for every common citizen of the country. I advise all the law students to necessarily remember that 4 virtues which Lord Rama told Vibhishan when the latter got extremely skeptical as to how Rama, a Vanvasi, a forest dweller, will achieve victory over the mighty Ravan. In Lanka Kand, Chaupal, Ramacharitra Lord Rama tells Vibhishan, which is beautifully scripted in Sri Ramacharitra Sauraj Dheer Jate Hirath Chaka Satya Sila Dhwaj Pataka Bal Vivek Dam Par Hit Ghore Chama Krupa Samatar Jujore, which means, and I'll explain in Hindi, शौर्य और धैर्य उस रथ के पहिए हैं, सत्य और शील सदाचार उसकी मजबूत ध्वजा और पताका है, बल विवेक दम इंद्रियों का वश में होना और परोपकार, ये 4 उसके घोड़े हैं जो क्षमा दया और समता रूपी डोरी से रथ में जोड़े हुए हैं. So it is therefore necessary that law students must have connect to the core value systems of our society, of our family, and comprehend the very purpose for which they have chosen law as their calling. Indianization of the judicial system is not just a legal reform, it is a step towards restoring India's legal identity. It aims to make justice more accessible, culturally relevant, and truly reflective of the needs of Indian society. The goal should be a synthesis, a system that possesses the analytical rigor and human rights safeguards of global legal traditions while functioning in a language, speed, and philosophical context that makes sense to the billions of people living in India today. The colonial hangover certainly is like a fog that prevents us from seeing our own landscapes clearly. You are the architects, you must clear that fog. Do not just study the law as it is, interrogate it for what it was meant to do, and then rewrite it for what India needs it to be. So let this conclave be the spark that ignites new ideas of a more equitable, accountable, and modern Indian judiciary. Thank you, Jai Hind.
Thank you, sir, for your inspiring words. I now invite Mr. Atul Sharma to kindly continue the discussion. Sir, please grace this podium. Can we please have a huge round of applause for sir?
Sorry. I'll restart. Justice Koteshwar Singh, Judge Supreme Court of India, Justice Dharmadhikari, Vice Chancellor Sahab, my friend Gautam, faculty members, and students. I have an easier job to do because a lot of it has already been done. But I will have a slightly discordant note to this discussion. Because if it was a debate, and if the motion was that is our legal system suffering from a colonial hangover, I would have spoken against the motion, because we are not. We have done so much in the last 70 years to make our legal system a fantastic piece of justice delivery system. When I come to this last part of my discussion, the problem is not what we have done with the system. The problem is how we are implementing it. Historically, if you look at the whole legal system, we had the presidency courts. Of course, earlier we had the religious courts. We had the presidency court in Calcutta, Bombay, Madras, which operated parallelly to indigenous adjudicatory system, largely based on religion and customs. It applied English law to the governed elite and customary laws to the masses. That was the whole setup. Once we became independent, of course, I'll just make a one-sentence statement, then move to the next part of it when I come to the further developments of the Constitution. As a choice of law, we chose common law. And we therefore incorporated Article 141 and 142 in the Constitution. And after we became independent, it's very interesting that we had a 3-year hiatus between independence and our Constitution being brought into force. And it was a brilliant piece of legislation which we created for ourselves as the Grundnorm. And it involved discussions from every section of the society. Having done that and having given to ourselves a constitution which even the people whom we say we were colonized by don't have one. They don't have a written constitution today. And what they went through during Brexit is a glaring example of how we have outsmarted them in this process of creating a Grundnorm, the constitution of ours. Rule of law. Rule of law, so far as India is concerned, is a codified system. If you look at England, the Magna Carta was an outcome of the discontentment between the king and the landlords at Runnymede. It was not an organized thought process system of governance that we chose. They chose. We chose that. But you can't take away from the whole jurisprudence of rule of law that the three concepts, the original concepts of Aristotle, Locke, and the third one is the, I think it was, yes, that's right. So these were the three philosophers who, in fact, created that whole concept of separation of powers. Now, what did we do with our Constitution? We created an absolutely independent scheme of separation of powers. Legislature, Parliament, Article 79 to 122. State Assemblies, Article 168 to 212. Executive, Central Government, 52 to 78. State governments, 153 to 167. Judiciary, Supreme Court Article 144 to 143, and High Court Articles 214 to 232, and subordinate courts Article 233 to 237. There's no constitution in the world which has created that dichotomy. And when it came to protecting ourselves, we created the whole edifice of Article 32 and 226, apart from Part 3 of the Constitution. And look at how we have evolved the whole law. Why do we need to discuss this, that we need to talk about the British system? That is wholly irrelevant for us today. The kind of evolution that our courts have done in interpreting, in upholding the Constitution, When it came to the attack on the Constitution, we consciously created a regime where we firewall the Constitution. And Keshavananda Bharati is not the beginning of that. Keshavananda Bharati was the consequence when it overruled Golaknath, and of course the whole Minerva Mills scheme of judgments. And of course, the Shankari Bai, and all that lines of judgments was clearly a very clear firewalling of the Constitution. Over the years, in the last 70 years, we have not only created a constitution for ourselves, we not only have interpreted all the laws in favor of the subjects, we have not only upheld the fundamental rights, but we have also promulgated thousands of laws which are relevant and to our lives, our systems, and our culture. Including, I don't need to get into that list of laws which we have formulated over the last 70 years. So in my respectful submission, I'm sorry, I'm becoming a counsel here. We have done everything what we needed to do to overcome, and we don't need to get to a stage where this topic evokes a feeling where you think that you immediately think of Shashi Tharoor's speech on reparations in the Oxford University. We need to cross beyond that. Where does the problem lie? The problem lies in the implementation phase. And here I'll be a little bit of tongue-in-cheek. The reforms in the justice delivery system have been a subject matter of a debate for a long time. We have done human work. The courts have done human work in ensuring that the justice delivery system is relevant to every section of the society. And it's amazing. The kind of work that we have heard during this discussion only, and large number of things that we have done to ensure that the justice delivery system is meaningful to the society is fine. The problem, in my very, very humble view, is we don't have a unified, standardized system of governance of courts. How do you expect a Chief Justice who has a 30 or 40-day period to implement reforms within his court and consequently in the courts down below to create a structure wherein there is a continuity? And of course, one of the reasons which, our judiciary has always faced criticism for inconsistencies in judgments. Now, how do you expect a system to be consistent with no formal structure? So today, Supreme Court and High Court is a conglomeration of brilliant judges who have achieved phenomenal success as practitioners, as judges in their own right, but they are not working as an institution, as a coherent institution. I will only end by referring to a very old incident. When I was, I think, 2 years into practice, I was approached by the then Mr. Umesh Thapar he was a renowned historian and journalist. He used to run a small weekly magazine called Lawless Laws. And he says, would you write an article in this? And in fact, it was one of the incidents when I went back to Professor Bakshi. I said, sir, I have to write an article. I've never written an article. Then Professor Bakshi was a legend. He is a legend. And then he narrated this incident to me, and I wrote on that in that periodical. He said during emergency, habeas corpus petition of one of the detainees came up for hearing before a vacation judge during June in the Supreme Court. And the learned judge, as he then was, transferred the matter to the regular bench during the after the vacations. And then he handed over an article to me, says, please read this. And the expression there was, of course, it was specifically talking about that habeas corpus position. I don't want to name. The learned judge of the Supreme Court, while deciding to adjourn the petition, the habeas corpus petition to post-vacation, forgot that he is not a judge on vacation. He is the vacation judge, and therefore he is the Supreme Court. So the problem is not what we have done. We have done wonderful work. Let's not pull down what we have done. That whole concept of, if I ask a simple question, if I walk into a Supreme Court judge's court wearing a dhoti, would the judgment change? No, it would not. Because the fundamental principles of law will remain the same. They will not change. So this is, in my humble view, this is a debate which is rhetorical and peripheral. We have incorporated so many of our traditions, and we will continue to incorporate what we have heard from the learned judges just a short while ago. But what we need to do is deliver the system, because every citizen of this country is a stakeholder in the justice delivery system. And we have examples in front of us where we can look at how we have organized our system. It's a simple illustration of the new businesses. You will find 40, 50 years ago, the old business houses were running their businesses in a different manner. They were not having organizations within their system. They were not getting the professionals. They changed. And the moment the IT companies, the Infosys of the world, Wipros of the world came into existence, they started realizing that, it's time that we get the support of the best in the business. Today's Supreme Court and High Court, there's nothing wrong with the system, there's nothing wrong with the judges. They need a support system. They both need at least 50 supports. Firstly, they need an organized governance structure. They also need support of professionals. At least 50 researchers. I'm sorry to say, with a tongue in cheek, I might say, and it is not at all with a view to denigrate any of you, how do you expect a 2-year or a new fresh graduate to really have that kind of a confidence to support her? You need, at least every judge needs 3 to 4, there should be a pool of about 50 to 70, 80 professionals centralized in every court system, which gives them the support that they need. I know this is a very tongue-in-cheek kind of a statement, and it is very, very, in some ways, not very palatable to young students, but then this is what we need to do. And if we continue to have this debate, we will never address the fundamental issue. Thank you.
Thank you, sir, for your inspiring words. I now invite our final speaker, Mr. Gautam Bhartikar. Sir, please come to the podium. Can we please have a huge round of applause for sir?
Justice Koteshwar Singh, Chief Judge of the Supreme Court of India, Justice Dharmendra Kari, Chief Justice of the Madras High Court, Mr. Atul Sharma, Managing Partner of Denton's Link Legal, Vice Chancellor, and my dear students and faculty of the National Law University, Bhopal. What today I'm going to do is, while we had two different scenarios from the judges and my friend Atul, what I'm trying to do is develop something in between by taking subject on the Admiralty Act of 2017, which is something which came into existence through the colonial system, but eventually had our own act. So the shift from the colonial inheritance to a modern reform. Next. Excuse me. Slide. So originally when we had the British Raj, we had the 4 acts that came into establishing the colonial system on admiralty, which is more to do with shipping law, which I practice about. The first act was the 1840 Act, which then was replaced by the 1861. And this year is of great importance because at this year, the Charter High Courts of India, Bombay, Madras, and Calcutta were established. Thereafter came the Colonial Courts of Admiralty Act, and thereafter, finally, the Colonial Court Admiralties India Act came into picture. So all these 5 acts actually designed the Admiralty jurisdiction of the Indian courts. The courts, so the Admiralty law is not practiced widely in India because it's more to do with the law relating to sea. Mostly you'll find the coastal state high courts, which eventually got jurisdictions under the new law, and I'll come to that in a minute. Next. So if you look at the law that came, which is the Admiralty Jurisdiction and Settlement of Maritime Claims, which deals with purely maritime claims, came to be brought about in the Indian systems exactly after 70 years of independence. What happened in the meantime? In the meantime, there was no steps by the legislature, so the judiciary steps in. Every judgment passed by the judiciary since then were based on English system, international conventions, and foreign law. That got developed over the years, and on the basis of which this became a very unique kind of a scenario where judges went on making law, which eventually then culminated into the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. So this was more a statutory framework rather than a framework which was adopted, but came over with the inheritance of the English law, but eventually became an Indian reform in 2017. Next. So I'll just go into how this system actually got about making this a very robust law. So the basic concept, what happens in Admiralty law is, there is something where whenever a vessel comes into India, regardless of its nationality, Indian courts get jurisdiction. And by which you have a basic concept where you arrest a vessel, that's called you detain the vessel, and basis that detention, you can, and basis the claim, and the claim has to be maritime claim, and therefore, on the basis of the maritime claim, a vessel is detained till such time a security is provided. So you, in fact, in these kind of proceedings, you have a concept where you have a security before agitating the dispute on merits. Then comes the jurisdiction. Prior to 2017, the jurisdiction was only with the chartered courts, which was Bombay, Madras, and Calcutta. But thereafter, with the new act, it has now decentralized the whole thing, and now the jurisdiction is with, which was more robust. The jurisdiction is with all the 7 coastal states, which goes from Gujarat on one side to West Bengal on the other. So the concept, while it was an English concept, got developed over the years, Indian judiciary acted very swiftly over the years, brought together a system in a way to actually develop a law which is a backbone of commerce. India has over 7,500 of coastline, and not having a maritime or not having an admiralty law was unfortunate for the 70 years of India's independence. But however, today we have the law, and it's an extremely robust law and works very, very swiftly because you have a security at the time of the first hearing itself. Then comes a very well-defined maritime claims. Section 4 of the Act defines actually the entire maritime claims, what could be the maritime claims, and basis which even the lawyers and even the litigants have a very clear demarcation whether the claim that has come up, is it a maritime claim or not. So it becomes a very, very funneled kind of a scenario when it comes to admiralty law. Next. So procedure I've already mentioned, I'll cut it short there. Then comes, there could be multiple claims against the same vessel or the vessel owner. What happens then? There is security already created. How a security is created? Security is created by way of a bank guarantee where the vessel which is detained is allowed to go. Or if the vessel owner is not able to provide security, there is a time period within which you sell the vessel. And the money comes into the court. And you have the security available for every claimant to utilize against their claims. Then how do you decide who takes it, who takes what? There is a very well-defined priorities of claims and payment out. So you have categories like liens, which has the highest priority. Then you have crew claims and other claims which are taken care of the crew and other stakeholders there. Then you have general claims. Then before that you have mortgage. So all these claims are very well defined. Basis which this law becomes a much well-structured, well-organized, not only when it comes to the legal framework, but also procedurally. So the rights on judicial sale I've dealt with. Next, please. So this is basically what the law says. While I didn't want to get into too much of detail because this is not the usual law which everybody practices. But just as a concluding remarks, so Admiralty Act of 17 reflects a broader legal evolution when it comes to Indian legal evolution. It not only just takes over the inherited colonial law, but also has reimagined and redefined the whole structure as to how this law should eventually be implemented. So largely speaking, this law has been, I would not say we are still on the hangover part, but I would not also say that we are lacking behind. We are way ahead of this system, and on the basis of which we have been able to achieve this, albeit 70 years down the line, but this system has been absolutely robust when it comes to shipping. With the Vision 2030 of maritime, with the Atmanirbhar Bharat of 2047, this law has come aptly at a time when things are looking positive for India, and there is growth. So having said that, similar exercises could be taken over. As Atul rightly said, it's not about going in the backward direction, but as Justice Dharmadhikari also said, that we need to take further steps and evaluate. So just like the Admiralty Act that came in 2017, we could also evaluate other laws. Is there a possibility to streamline it? If not, we are still following the common law system, but is there a possibility to streamline it in a way that the procedural length can be reduced and thereafter the litigants get their rightful share of justice within the available time limit? With that, I thank you for being here, and thank you.
Thank you, sir, for your words of wisdom. Due to paucity of time, we would now want to proceed to the distribution of mementos to the HODs, deans, and professors of the participating universities of Bhopal who have graced this occasion with their presence.
A very good afternoon to our esteemed dignitaries, respected faculty members, and students present here. Due to the paucity of time, we will begin with the memento felicitation of the faculty members present here.
I humbly request our Chief Guest, Honorable Justice M. Koteshwar Singh, to kindly present mementos to the representatives of the participating universities as a token of our gratitude. With great respect and gratitude, I would like to invite our respected delegates to kindly come up on the stage as their names are called. First, we invite Dr. Shikha Srivastava ma'am from Infotech Education Society University.
Let us give her a huge round of applause.
Next, can we have Professor Tai Chaurasia ma'am from Mansarovar Global University. Next, can we please have Dr. Yogesh from Mansarovar Global University. Next, may we request Dr. Atul Tiwari, Principal, Technocrats Institute of Technology. Mr. Devesh Bhargav, in charge HOD, Technocrats Institute of Technology. And Ms. Anushka, Assistant Professor, Technocrats Institute Technology. We would now like to invite Dr. Naish Zamir ma'am from Ravindranath Tagore University. Dr. Yogini Upadhyay from LNCT University. Mr. Durgendra Singh Rajput from LNCT University. And Dr. Pramod Kumar from SAM Global University.
Can we have a huge round of applause for everyone present here? Yes, that's it. Now, I would like to invite all the SBA representatives to please join us on stage for a group picture. Everyone is requested to please remain seated. We are about to begin with our valedictory ceremony. Before we begin the ceremony, it is my absolute privilege to invite Mr. Radhelal Gupta, Chairman, State Bar Council, Madhya Pradesh, and former ASG, to kindly join us on the stage. Can we have a huge round of applause for him? A very good afternoon to everyone present here. It is my honor to welcome you all to the valedictory ceremony of the second edition of the NLIU-SBA Law Conclave. Today, it is our privilege to host an extraordinary panel of guests. I extend a heartfelt welcome to Honorable Justice Shri N. Koteshwar Singh, Judge, Supreme Court of India, our chief guest today. Born in Imphal, Manipur, into a distinguished legal family, he earned his LLB from Delhi University. After practicing in the Supreme Court and Guwahati High Court, he served as Advocate General of Manipur and was designated Senior Advocate. Elevated as a judge of the Guwahati High Court in 2011, he later became Acting Chief Justice of the Manipur and Guwahati High Courts and Chief Justice of the High Court of Jammu Kashmir and Ladakh in 2023. On 18th July 2024, he was elevated to the Supreme Court, becoming the first judge from Manipur and only the second from the Northeast to reach the apex court. Sir, we are deeply honored by your presence today.
We are deeply honored to welcome Honorable Justice S.A. Dharmadhikari, Chief Justice of the Madras High Court, as our guest of honor for this valedictory ceremony. Justice Dharmadhikari began his legal career in 1992 at the Madhya Pradesh High Court, later serving as a standing counsel for the Union of India for over a decade. He also served as a welfare commissioner for the victims of the Bhopal gas tragedy. He was elevated as a judge of the Madhya Pradesh High Court in 2016. Later, he was transferred to the Kerala High Court in 2025. And in March 2026, he became the Chief Justice of Madras High Court. Sir, your presence is a source of immense inspiration and pride for this institution.
Next, we are honored to welcome Mr. Radhelal Gupta, Chairman, State Bar Council, Madhya Pradesh, and former ESG, as our distinguished guest. Mr. Radhelal Gupta has been practicing law since 1978, completing 43 years in the profession. He served in the chambers of late Shri S.A. Avasthi and later under Shri D.M. Dharmadhikari, who became a judge of the Madhya Pradesh High Court and the Supreme Court of India. He has held several prestigious positions, including former Assistant Solicitor General of India and former Additional Standing Counsel for the Government of Chhattisgarh in the MP High Court and Special Prosecutor for the CBI from 2007 to 2011. He has been elected 4 times as a member of the State Bar Council of Madhya Pradesh from 2002 onwards, serving as treasurer, co-chairman, spokesperson, and on various committees, including the disciplinary and executive committees. Known for his quick wit and calm demeanor, he has fought many high-profile cases and maintains a flourishing practice in the MP High Court, specializing in constitutional, service, civil, criminal, and revenue law. We are honored to have you here with us, sir.
We are deeply privileged to have with us our Honorable Vice Chancellor, Sir, Professor Dr. S. Surya Prakash. He has previously served as Vice Chancellor of DSNLU Visakhapatnam. We are truly honored to have you, sir.
Can we please have a huge round of applause for all our esteemed guests?
As we come to the close of this incredible journey, it is only fitting to pause and acknowledge the national significance for this movement. The second NLIU-SBA Law Conclave has been a truly special and enriching experience for all of us. For over the past 2 days, we witnessed insightful discussions, enriching and thought-provoking podcasts and engaging panel discussions that brought together perspectives from the bar, bench, and beyond. From conversations on arbitration reforms to discussions on access to justice and the future of legal education, every session left us with something meaningful to take back. The enthusiasm and participation we witnessed, especially during the quiz and other activities, truly reflected the spirit of collaboration and passion for learning. And above all, the conclave successfully created a platform for meaningful dialogue and exchange of ideas, staying true to its theme, that is, imagining law and justice in the 21st century.
As a token of our gratitude, we are honored to present our esteemed guests with bouquets, symbols of our heartfelt appreciation and respect. Their presence and support have truly made this occasion special. I kindly request Professor Dr. S. Surya Prakash to present the bouquet and memento to our Chief Guest, Honorable Justice N. Koteshwar Singh. Can we have a huge round of applause, please? Now, I kindly request Professor Dr. S. Surya Prakash to present the bouquet and memento to our guest of honor, Honorable Justice S. A. Dharmadhikari. Can we have a round of applause, please? Next, I would like to request. Next, I would like to request Professor Dr. Raka Arya to present the bouquet and memento to our distinguished guest, Mr. Radhelal Gupta. Can we have a round of applause? Next, I would like to request Mr. Priyanshu Gupta to present the bouquet to our Honorable Vice Chancellor, Sir. Can we have a huge round of applause, please? With this, we extend our warmest welcome once again to our esteemed guests and look forward to their invaluable insights and words of wisdom throughout the ceremony.
I now kindly request our Honorable Vice Chancellor, Professor Dr. S. Suryaprakash, whose profound insights have consistently inspired the NLIU community, to please address the gathering.
Good evening to all. Honorable Justice Sri Koteshwar Singh Ji, Honorable Justice Sri Dharmadhikari Ji, and distinguished guests Sri Ladilal Gupta Ji, and all distinguished juries, teachers, and students. As all good things has to come to an end, so this second SBA student conclave. Our SBA has been working for the last few months to make this a grand success. Give a big round of applause to the SBA. And I'm, due to paucity of time, sir, with your Lordship's kind permission, it was a hangover will be of different types, but this is the academic hangover. Being a teacher, I should say what Honorable Justice Koteshwar Singh Ji has stated. This is only supplementary and complementary. So, sir has stated about the Hinduism. And here, the factual situation was that in the 17th century, the East India Company also got whether it is some charter, I could not recollect the year, permission to bring the Christian missionaries also to India to propagate the religion. Okay? So, what has happened when they came, they started looking into these people, their practices. So there are so many theories. Earlier, the Abrahamic religion, there is only one text, one God or messenger of God, something like that. Here, there is Saivism, there is Vaishnavism, there is Dvaitam, there is Advaitam, there is Vishishtadvaitam, there is Veerasaivam, there is Kapalikas, and so many theories, so many gods, they are utter confused. Oh, this is Hinduism, it is not a religion. And they could not understand the philosophies, the theories, the faithful and faiths of different sects and subsects. And so they said that because they could not understand, they could not comprehend the philosophy, the Vedas, the Upanishads, so many Puranas, they are utter confusion. They said that no, there is no one God. And hence this is not a religion. And this has become the coffee table discussion at many places. So, my humble submission, sir, Hinduism is a religion. And let me take 30 seconds, not more than that. And sir has stated that, unfortunately, most of our Sanskrit texts, they have been translated by particularly the persons like Max Muller, whatever may be their passion or fascination for Hindu religion. Let me tell you only one thing. When we go to temple, so at the end of the puja, the priest will say that Sahasra Sirsham Devam Viswaksharam Visashambhavam Iswam Narayanam Devam Aksharam Param Padam Visatha Paramanityam, and it will continue. And this was translated by the German scholar. Sahasra Sirsham Devam Viswaksharam Visasham. So this is Sahasra Sirsham means the Vishnu or the God. It is a symbolic presentation that the God has 1,000 hands, means he is omnipotent, he is everywhere. That is the meaning. And it was literary translation, Hindu God has 1,000 hands. And then came the other materialists, how a human being can have 1,000 gods. So there is a lot of misinterpretation of Sanskrit text. Sir, as he rightly said that we should learn our own text and we should make our own translation. With these few words, sir, your paper was excellent, and how you have connected and you have reminded us that we should learn Sanskrit. And I express my gratitude to all the panelists, all the scholars of the previous sessions, and the juries for this session, and all the audience who has a lot of patience for the last 2 days. And I welcome you all for the third legal conclave also. Thank you very much. Jai Hind.
Thank you so much for your insightful words, sir. And now, to celebrate the immense contribution in the organization and in support of this event, I would like to invite Mr. Siddharth R. Gupta, Advocate, Supreme Court of India, on the stage. I would also like to invite all the SBA representatives to be on the stage for a group photo. Can we have a huge round of applause, please? We now move to a significant moment in this conclave, the formal signing of the Memorandum of Understanding between NLIU Bhopal and the General Councils Association of India. This collaboration marks a meaningful step towards strengthening academic and professional engagement, fostering research, and creating greater opportunities for our students. The GCAI, an independent body led by in-house legal professionals, is guided by the motto, Strategizer, Enabler, Protector. Its flagship initiative, Nyaya Nirman, convenes jurists, policymakers, and corporate leaders to deliberate on legal reforms. We are honored to have presence of our chief guest, Honorable Justice N. Koteshwar Singh, and our guest of honor, Honorable Justice S. A. Dharmadhikari, on this occasion. I now invite Mr. C. V. Raghu, Principal and President and Founder, GCAI, Mr. Sujat Bin Ali, ExCom Member, 4th Partner Energy, and Ms. Sonal Basu, Senior Vice President and Group General Counsel, Excendion, to join our Honorable Vice Chancellor on stage for the signing. I also call upon Mr. Priyanshu Gupta, President of the SBA, to please be present on the stage. Can we have a huge round of applause? I also invite Professor Dr. Raka Arya, Dean of Student Welfare, on the stage. Can we have a huge round of applause for all the guests present on the stage? Can we once again have a huge round of applause for this momentous occasion?
We move on to the most anticipated address of this valedictory ceremony. I have the highest honor of inviting Honorable Justice N. Koteshwar Singh, Judge Supreme Court of India, and our esteemed chief guest, whose judgments have consistently reflected a deep commitment to justice, equity, and the human dimension of law. Your Lordship, please grace the podium to address the gathering.
Thank you very much again, the Honorable Justice Dharmendra Kariji, Honorable Chief Justice, and the Vice Chancellor and other dignitaries on the dais, and off the dais also. As we come to the concluding session part of this program, I just wanted to emphasize, just what I want to say is that, see, all function under the Constitution, and what is required to be done should be done, which should strengthen the Constitution, because ultimately it is the basic document under which all of us function and exist. In fact, what Dr. B.R. Ambedkar, whose birthday we are going to celebrate in a couple of days, he said that the Constitution is not a mere lawyer's document, it is a vehicle of life, and its spirit is always the spirit of the age. And of course, he says, continues to say that constitutional morality is not a natural sentiment, it has to be cultivated. We must realize that our people have yet to learn it. How do we strengthen this? Therefore, going to the past does not mean replacing, it's not supplanting, supplementing the rich heritage. I will not take much time. Just I read out a very interesting, the first paragraph of the judgment of the Honorable Supreme Court in Santosh Kumar and others versus the Secretary, AIR 1995, Supreme Court 293. The first paragraph. A professor of Cambridge University is deeply engrossed in his studies. In his clam chamber, an agitated English soldier enters the study room and accuses the professor of not sharing the trauma of war, which he and many others like him are facing while fighting Germans. The professor calmly asks the young soldier for whom he is fighting for. Quick comes the reply that it is to defend the country. The wise man wants to know what is that country to defend which he is prepared to shed his blood. The soldier replies, it is the territory and its people. On further questioning, the soldier says, it is not only this, but the culture of the country which he wants to defend. The professor quietly states that he is contributing to that culture. The soldier calms down and bows in respect to the professors and vows to defend with more vigor the cultural heritage of his country. This is what is said to have happened during the Second World War, when England was fighting almost a last-ditch battle of survival, and all Englishmen contributed in their own way to eliminate victory of England. The above shows the concern of culture evinced even by the Westerners. So far as we, the people of India, are concerned, they have always held in high esteem the cultural heritage of this ancient land. Now this paragraph appears to be out of context. No, because there was a case filed before the Supreme Court to include Sanskrit as an elective language in NCERT. Therefore, they said, well, if you include this language, there will be demand for other languages, even foreign languages, Arabic, Persian, and all, German. They said, no, this is the basic value on which this country has evolved, grown up. Therefore, at least provide that. In fact, the Supreme Court directed that, yes, include Sanskrit as an elective. Sanskrit, today's linguists would say, is perhaps the finest, the most developed language. It is only language which is compatible to computer language. Therefore, what I'm trying to say is that, see, ultimately this is this country, it is this constitution and one of the finest constitution we have. Some of the finest brains contributed to make this constitution. How to strengthen it? Because we have lost our understanding of our own country. In the process, many of the problems have arisen. Lack of understanding, lack of empathy, this polarization, this spewing of venoms in the social media. This was not really part of this ancient tradition. That is why I took pains to go back to our traditions which we have not understood, which requires to be understood. And as far as the constitution goes, we must always remember what B.R. Ambedkar again warned. However good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing are not good, it will prove to be good. Therefore, these are just to remind ourselves the responsibility as citizens of this country. Whatever exercise we do, even in this small exercise we have undertaken today, it may appear to be small, but it has huge potential for the future law students, the lawyers, the judges, academicians. Today's students are the future foundation of the legal system of this country. The jurisprudence will be evolved. Jurisprudence will evolve, will be strengthened by them. But I am sure with a holistic understanding of the rich past, the present constitution can be strengthened. With this thought, I wish all the success for this 2 days symposium which has been going on, and it will contribute to the strengthening of the constitutionalism, the rule of law, without which this country will flounder. Thank you very much for your...
I thank your Lordship for his highly motivating and gracious words. We are deeply honored to have the presence of Honorable Justice N. Koteshwar Singh here with us today.
I now kindly request our respected Dean of Student Welfare, Professor Dr. Raka Arya, whose unwavering dedication and empathetic guidance have greatly enriched student life at NLIU, to please address the gathering. Can we please welcome her with a huge round of applause?
Thank you, Sheetal. Thank you, Rashi. It's an honor and privilege to stand before such an orchestra, looking ahead, step by step, with the changes which are happening all around us. What we have found out after hearing today, Honorable Sir, that yes, we are very much into this. Even the judicial system, the highest judiciary, is not left behind this particular endeavor of walking step by step with the changes which are coming to this country. Because we all know that this is something that a person should have his own identity. That speaks volumes, that what I stand for, the values, the principles, the other things that I am standing for. I think that has been reiterated and endorsed because we do know that currently the life is hanging between two things, commercialization and values. Whether commercialization will take the sacrifice of the values. So I think that being a country that is a civilizational country, that has been proven by all the experts, those who have delivered their addresses in this gathering, that yes, we are very well you're walking with the time. And once again, India, being a civilizational state, proving its worth, that it is, because of its ancient wisdom, because of its ancestry, and the kind of things we have on our disposal, we have an edge in comparison to other civilizational states. So we will never be left behind. We were always a guiding light, as Sir has also made a mention today, and we will be a guiding light. So we are very well in the concept of Vishwaguru. We have the competence, we have the capability, we have the experience, and we have everything with us. With these words, I would like to thank all of you who have come here, participated. Sir, especially, I would like to give my thanks to you, because we know that you have very busy schedule and all that. So especially my thank goes to all the honorable justices who all have came and spent time with us, because we know that the whole exercise was meant for those who are holding the future for us. Thank you very much, sir. Thank you.
We now move on to a very exciting segment of the conclave, the quiz competition felicitation ceremony. This year marked the first time that the SBA organized a national level quiz competition as a part of the conclave, and the response we received was truly overwhelming. We witnessed enthusiastic participation from numerous teams, each bringing remarkable knowledge, competitive spirit, and energy to the event. The level of engagement and enthusiasm clearly reflected the success of this initiative, and we hope to carry this forward in the years to come. Now, without further ado, let us celebrate excellence and acknowledge the outstanding performers. I would request our Chief Guest, Honorable Justice Shri N. Koteshwar Singh, Judge, Supreme Court of India, to honor the winners by felicitating them. We begin with the second runner-up. Okay. The second runner-up is Ramanuj Pandey, Akash Singh Thakur, Tejas Vyas from NLIU Nagpur. Let's have a huge round of applause for their commendable performance and spirit. Can we please have the team from NLIU Nagpur on stage? Let's have a huge round of applause, please. Next, the first runner-up. The first runners-up is Kabir Dubey, Parth Jade from Vidhigya Institute. A big round of applause for their great performance. Can we please have them on stage? Let's have a huge round of applause, please. The second runners-up have been awarded a prize money of ₹21,000 rupees, and the first runners-up have been granted the prize money of ₹31,000 rupees. And now, the moment we have all been waiting for, the winners. The winners of the quiz competition are Abhigyan Sandila, Yasir Abdullah, and Arpit Yadav from Jamia Millia Islamia. Let's give them a big round of applause for their exceptional achievement. I would also like to invite Mr. Siddharth R. Gupta on stage to facilitate the winners. Along with the trophy, the winners are also granted a prize money of ₹51,000 rupees. Congratulations. Congratulations to all the teams for making this competition so engaging and memorable. I request all the guests to please remain seated as we continue with the valedictory ceremony. I now invite Mr. C.V. Raghu, President and Founder of GCAI, on stage to please address the gathering. Can we please welcome him with a huge round of applause?
Good evening. I know all of you must be having a tiring day, and I might come in between you and you guys going back home. But let me just, honorable judges on the stage, distinguished guests, and my friends. As you would have noticed, we signed a MOU with Law School at Bhopal. I represent the General Counsel Association of India, which is a very nascent organization, which we started about 5 years back. We actually had our 5th anniversary on 5th of March. So we're just about 5 years old. We are still in our infancy. But what has been the purpose of GCI? We believe that as law is progressing, so is the role of in-house counsels progressing. It has become a very distinguished line of legal practice, which has for so many years not been recognized at all. So we felt the need for a distinct voice for the general counsels and in-house counsels. That was the intent. This is run by general counsels for the general counsels of the general counsels. And this association, the 3-4 important key objectives. First objective is that we fight for the recognition of in-house counsels as another stream of lawyers, which has, there is some debate happening on the Advocates Act, which we have represented both at the Bar Council level as well as we moved interventions applications before the Supreme Court. And we are hoping at some point in time, because today, India cannot progress without the industry progressing, and industry cannot progress without the support of in-house counsels, who play a very significant strategic role in the companies, in corporate India. The second thing is that we also use this forum to train future lawyers. One of the flagship things that we did in the month of January was a 30-day internship program, which most law schools have been giving us feedback that internship is a very difficult thing. And this morning also I mentioned, this is the first internship of its kind where we had law students coming from 15 different law schools across India under one roof, spending 30 days. We had 75 distinguished industry speakers who spoke, and it was both a question and answer session. It had various elements of assignments, all different kinds of things. It also had a blend of visits to important places. We took them to the Parliament. We took them to the Supreme Court. I know a lot of lawyers who have been practicing for 15 odd years, but have never been to the Parliament. We took them to the industry. We took them to the Maruti factory, where they saw actually how cars are manufactured. We took them to Wipro. We took them to the War Memorial. So the idea was that you give them a very experiential internship program. So we intend to keep repeating that, and this year we are a little more ambitious. We want to do it both in Delhi and Mumbai and double the capacity. We actually gave away certificates to 120 students in a valedictory function that happened on 31st. Honorable Minister Medwal Saab was there, and various other Ministry of Corporate Affairs, they were all there. The second thing is that we also run a very flagship program called Nyaya Nirman, which we hold once a year, which is about how should India and Indian legal system change or adapt itself towards the vision of Viksit Bharat 2047. And and all the deliberations, we have presented that to the ministry for them to think about it and evaluate how it can be improved. The third important thing is that we do a lot of mentoring program for law students as well as young practicing lawyers. So anybody wants to have individual mentoring, we are there. Last but not the least, we also want to do legal advocacy, because we've often felt that most of the advocacy at a ministry level that happens through CII, happens through law firms, but a very significant segment of lawyers who are actually the implementers. General counsels are actually the implementers of law. The last mile of the implementation of law is done by us. Their voices are never heard. So we want to actually play a very critical role in doing that. And just from my personal experience, when the company law came out in 2013-14, I personally made 107 recommendations, out of which about 84 were accepted by the Ministry of Corporate Affairs. So the question is that we have to raise our voice, we have to up the voice of the general counsels, and all our members are distinguished general counsels who have served nearly 2.5, 3 decades in the industry, who have contributed significantly, but their voice has to be heard, because they bring a huge amount of wealth in the legal profession, and we hope someday that we'll see the light of, and I'm very impressed after I came here to see that there is something known as a Students' Bar Association. Maybe that is signaling us to start something called a General Counsel's Bar Association as well. Thank you very much for hearing me. Thank you. Thank you, sir.
As we come to the end of this conclave, we want to thank everyone who made this event possible. To deliver the vote of thanks, I invite Mr. Priyanshu Gupta, President, Student Bar Association, to the podium. Let us give him a warm welcome.
Good evening, everyone. It is my profound privilege as the President of the Student Bar Association NLIU Bhopal to deliver the vote of thanks today. At the outset, I expressed our deepest gratitude to our esteemed dignitaries who graced the inaugural day of this conclave. We are truly privileged to have Honorable Justice Sanjay Karol as our chief guest, whose presence set a tone of constitutional depth and judicial wisdom. We remain equally honored by the presence of Honorable Justice S.A. Dharmadhikari, Chief Justice of Madras High Court, whose insights continue to inspire both the bench and the bar. We extend our sincere thanks to Honorable Justice Pankaj Mittal, who joined us virtually and enriched the discourse, and also Honorable Justice M.I. Arun, Judge, High Court of Karnataka. Day 1 of the conclave saw an intellectual discourse, the discussion on revisiting arbitration jurisprudence and strengthening the grassroots of justice through technology sparked meaningful dialogue and critical reflection. I extend my sincere appreciation to all the panelists for Day 1 session. On Day 2, we were deeply honored to be joined by an exceptional panel of dignitaries. We extend our heartfelt gratitude to our chief guest, Honorable Justice and Koteshwar Singh, Judge, Supreme Court of India, whose remarkable journey and constitutional vision continue to inspire generations of legal minds. We are equally grateful to our guest of honor for the valedictory ceremony, Honorable Justice S.A. Dharmadhikari, sir, Chief Justice of the Madras High Court, whose distinguished career and unwavering commitment to the justice have left an enduring impact. We also extend our sincere appreciation to Mr. Radhilal Gupta, Chairman of the State Bar Council of Madhya Pradesh and former Assistant Solicitor General, whose decades of experience at the bar have brought great significance to this conclave. Further, we express our deep gratitude to our Honorable Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, for his constant institutional support, and to our Dean Student Welfare and SBA Faculty Advisor, Professor Dr. Raka Arya, whose commitment to student welfare and academic excellence continues to shape this institution in a meaningful ways. Day 2 witnessed engaging discussion on 2 pressing issues, one on preparing law students to be industry ready, another on re-examining the colonial influence on the legal system. I again thank all the panelists for Day 2 for the enriching discourse. A special note of thanks to Registrar Sir, our faculty members, administrative staff, and every individual who worked tirelessly behind the scenes to ensure the seamless execution of this conclave. Your efforts truly form the backbone of initiatives like this. To our participants and audience, your curiosity, engagement, and thoughtful questions are what brought this conclave to life. Finally, I extend my heartfelt appreciation to the members of the Student Bar Association and our organizing committee volunteers, my friends, juniors, and all the administrative staff. This conclave stands as a testament to what student-led initiative can achieve when driven by purpose, passion, and collaboration. With that, we bring this enriching journey to a close. Thank you for your presence, your time, and your invaluable contribution. The NLIU-SBA Law Conclave now draws to a close, but its spirit continues to echo through its motto, Bar, Bench, and Beyond. Thank you. Jai Hind, Jai Bharat.
We now request everyone to rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता
All dignitaries are requested to proceed for the high tea. The audience is requested to leave after our esteemed dignitaries have departed. I once again heartily thank everyone present for making this event a solid success. All the participants are requested to move outside convention for the high tea.